Okay. All right, folks. Good morning. My name is Judge Law. Mr. Haddad, good morning. Ms. Greenhouse, Mr. Rhodes, all the usual suspects. Okay, there we go, Mr. Scirocco. Good morning, folks. All right, folks. Mr. Haddad, are we ready to proceed? I don't see as many people as I have on the calendar, so we good to go?
We're ready on the first one seated next to me. The gentleman in the back, Judge, one of them is proceeding pro se. The other three are conflict cases, Judge.
Okay, and let's see now. Well, let me begin with who we have. Good morning. My name is Judge Law, and we're going to begin with our all-purpose calendar. So we're going to ascertain how the defendants would like to proceed with their cases, their misdemeanor cases today. If you are a defendant who is charged with a misdemeanor offense or offenses, please remember that you have the right to remain silent. Anything that you choose to say at this virtual proceeding, your statements can and will be used against you in the treatment of your case. You have also a right to an attorney. If you cannot afford one, one will be appointed to represent you. Today, the defendant would, with the advice of counsel, advise the court as to whether they would like to accept a plea offer from the prosecution and enter a plea of guilty or no contest to the same or reduced charges, or if they would like to proceed with the trial and enter a not guilty plea. So, Mr. Haddad, who do we have with you?
Judge, this is position number 24, Rodriguez Matthews.
Okay.
And that's the negotiated plea, Judge.
Okay. I do apologize. I haven't printed out the PD's report on status, so I'm going to count on you for a little while. Rodriguez Matthews is case 25 CR 005549E, accused of criminal trespass from September 10th, 2025. Mr. Matthews, I understand that you'll be entering a plea, so may I please place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right. And Mr. Scirocco, good morning. And what's this recommendation for Mr. Matthews?
Good morning, Your Honor. The state's recommendation for Mr. Matthews on the criminal trespass is 12 months, served 60 days, credit for time served 15 days. It's from 9/11/25 to present, balance probated, behavioral health evaluation, and any recommended treatment. Stay away from all GSU premises and property, and 40 hours community service. We ask that defense stipulate the factual basis, venue, and ID for purposes of the plea.
Mr. Haddad, do you so stipulate?
We stipulate, Judge, I would ask the court to consider waiving the first 2 months probation fees and consider non-report probation once all the conditions are completed, Judge.
No. I will waive the probation fees for the first 2 months, starting from the time that he begins. I understand he has additional time to serve at the jail.
With respect to non-reporting, I would just say that he is in violation of current probation that he entered into on July 31st.
So Mr. Matthews says, I was going to say, I'm not comfortable with the non-reporting because I do know that Mr. Matthews had one or more probation cases when he was arrested for this charge.
Judge, that'd be fine, Judge. At least to waive, and I think the court was gracious enough to waive the first 2 months, Judge.
And I'm so sorry, but does he understand that he will be reporting for other probation matters in addition to this one once he's released from jail?
I understand. He needs to say it.
Yes, Your Honor.
Okay. Mr. Matthews, have you consumed any medicine or alcohol recently?
No, Your Honor.
And have you understood what's going on in your case?
Yes, sir.
I'm not convinced that you understand.
I understand, Your Honor.
How many probation cases do you have? What?
One.
One. So this would make it what?
Final plea,
This would make it 2 probation cases.
two probation.
All right. And are you satisfied with your attorney?
Yes, Your Honor.
And are you entering this guilty plea freely, willingly, and knowingly?
Yes, Your Honor.
So you understand that you will not be able to go back and challenge this charge in a court of law. You won't get a trial. You won't get an attorney to help you challenge the evidence brought against you, confront those accusing you of this charge, and the prosecution won't have to do its job to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yeah.
How do you plead to one more count of criminal trespass?
Yes, Your Honor.
Your sentence is 12 months to serve 60 days, credit for time served 15 days. I understand you have 15 more days to serve at the Fulton County Jail. Once you are released, you will report to the Fulton County Probation, and you will have 2 probation cases to report about. I will waive your probation fees for the first 2 months for this case only, not for the other case, for this case. You'll be required to do 40 hours of voluntary community service, and you have to do it at any nonprofit agency. And it cannot be a school, and it cannot be a church. And you would have to do a minimum of 10 hours per month.
No.
Do you understand what I'm saying?
Yes.
You are to stay away from all property that belongs to the Georgia State University, which will include their college buildings, their classrooms, their cafeteria, and their parking decks. Understood? Yes or no?
Yes, Your Honor.
All right. And yeah, I guess that's it. Oh, and you have to do a behavioral health evaluation. So as soon as you're released, you will need to go make an appointment with your doctor, who will recommend a behavioral evaluator, and you need to undergo one of those and submit yourself to treatment. Thank you.
Thank you, Judge.
Sir? Number 41, Washington.
41. Okay. Eddie Washington is accused of 2 misdemeanor charges under accusation 25 CR 5562G from September 11th of this year, violating a family violence protective order and willful obstruction of a law enforcement officer. Mr. Washington, you've been advised of your rights, and your attorney is Mr. Haddad. Would that be correct, or is this pro se?
He's pro se, Judge.
All right. Mr. Washington, as I've already advised you, you do have a right to remain silent. In addition to that, you have a right to counsel. If you cannot afford one, the Public Defender's Office may be appointed to represent you. But if you choose to waive your right to appointed counsel, you have a right to hire an attorney. Have you done so?
No.
Okay. And if you have not hired an attorney, you also have the option of representing yourself. If you choose to represent yourself, I and the law expects that you understand criminal law and criminal procedure and how it applies to the facts of your case. You will not have the benefit of any legal advice from an attorney, such as the one seated next to you, and you would have to proceed to your own detriment. So, are you prepared to waive your right to counsel and proceed with representing yourself?
I stated this last time in court, ma'am, I was, and now you're reiterating something as if I'm negligent or at risk of hurting myself or somebody else. But I did state this in our initial trial. Did you review our initial court date, ma'am?
I have no recollection of you, sir. So could you refresh my memory about what you asked for?
I asked to represent myself because I had been maliciously prosecuted by the arresting officers and their team.
Okay, so that is a matter that you would have to take up as a separate lawsuit. But in the present case, with these 2 charges, are you waiving your right to counsel?
Yes, ma'am. With these-
Okay. That's
Ma'am, I took,
something,
ma'am.
no,
I
no,
took an
no,
instruction,
no, no. If you're gonna continue talking, I'll see you next week. All right, good. I want to know right now, have you reviewed the charges and have you reviewed the offer from the prosecution with regards to the two charges against you?
I haven't received the offer, ma'am.
All right.
I asked the law library and I was denied.
So we are going to have Mr. Scirocco recommend the offer. And if you want to consider it, we will be glad to send you the paperwork to go over. And then you can then tell me later this morning how you would like to proceed with your case. Mr. Scirocco, and listen very carefully, Mr. Washington, I'm only going to make him say it once.
The state's recommendation for this case on count one is, which is the violating the Family Violence Protective Order, is 12 months, served 60 days. Credit for time served 14 days. Balance probated. No further contact with Shaquille Brown. No further contact with Amia Jones. Stay away from 2875 Harper Valley Drive in South Fulton and an Op 21 law and decision-making course. And count two, the willful obstruction, is 12 months probation concurrent with count one and a $300 fine.
Decline.
All right. So basically, you would have to spend an additional 14 to 15 days at the Fulton County Jail, have no contact with two victims, stay away from Harper Valley Drive, and undergo an Op 21 law and decision-making course. And these would be the conditions of probation. And for the willful obstruction, that would be concurrent with count one with an addition of a $300 fine. That's the recommendation. Would you like to consider that?
You said what, ma'am?
Would you like to consider that
Can you repeat
in
that?
terms of entering a guilty plea to that recommended sentence?
Could you repeat everything you said, ma'am?
I said you have heard from the prosecutor what they are recommending as a sentence if you decide to plead guilty to these charges. Would you like to consider that offer?
You said $300. You said $300 fine with an additional 14 days.
You would have to serve an additional 14 to 15 days at the jail. Then you will be on probation. You would need to stay away from two victims, stay away from the Harper Valley Drive, undergo a law and decision-making course. Plus, you would have to pay a $300 fine. Plus, you report to probation once a month for the remainder of your probation.
And it would be an additional 16 days in jail.
Oh, sorry, it's an additional 16 days at the jail. All right, so if you'd like to have a seat, we'll come back to you once you think about it. All right, Deputy, we're going to hold on
I
Eddie.
decline, ma'am.
I'm sorry?
I decline.
Okay, please sit down then. So if you're, all right, Mr. Washington, I'm going to deem this as a not guilty.
Yeah, please.
Have a seat in the chair behind you. So, Mr. Washington, Mr. Haddad, please direct him to be seated next to you. Thank you so much. Okay. All right, Mr. Washington, since you declined the state's recommendation, then it will be tantamount to a not guilty plea. Let me just advise you that you are charged with two misdemeanor offenses, violating a family violence protective order and a willful obstruction of a law enforcement officer. Would you like me to read the accusations in detail in open court, or do you waive a reading of the accusation?
I'll waive a reading of the accusations, ma'am.
All right. So, and with regards to these two charges that have been accused against you, you have a right to a jury trial or a bench trial. You don't have to make the decision right now, but
Bench trial.
a what trial?
Bench trial, ma'am.
Bench trial. Okay. Your case will then be reset for a bench trial. Presently, you are presumed innocent in the eyes of the law, and the case will go to a bench trial where the prosecutor would have to prove the charges against you beyond a reasonable doubt. If the prosecution does prove the charges beyond a reasonable doubt and overcomes your legal presumption of innocence, you could be convicted of one or more of these misdemeanor offenses. The penalty for each misdemeanor offense would be up to 1 year in prison and or up to $1,000 fine for each charge. These sentences could be run concurrently or they could be run consecutively. Given this information, how do you plead?
Not guilty, ma'am.
All right, your case.
Can you address me as Eddie Washington, Doctorate of Education or Master's of Business Management, please, ma'am?
I'm sorry, repeat the question.
Can you address me as Eddie Washington, Master's of Business Management or?
I'm only going to address you as Mr. Washington. And Mr. Washington, since you've entered a not guilty plea, your case is going to be further noticed for a trial. And your bond is currently a $2,000 good bond. Once you make bond, please remember to maintain a current mailing address with the court so that we can send you your summons of when to appear in court for trial. If you're still
Thank you for lowering
detained,
my bond, ma'am.
I'm sorry?
Thank you for lowering my bond.
Your bond is $2,000, it's a surety bond.
Last time it was more than that. I said, thank you for lowering my bond.
I did lower your bond. Your bond has always been 2,000 surety. Well, I don't know what other bond you have, but for this case, it's $2,000 surety.
Okay, because I was only stating last time you gave me my bond, you went off of a probation violation and unfair to appear, and that case was sealed by Judge Knight in the state of Indiana as a condition of that probation that they said that would fall off of my record and not be admissible in any further proceedings.
You have a $2,000 surety bond. Thank you, sir.
Can I also apply for a judicial change, ma'am?
Yes, I won't be your judge anymore, so to be happy.
ma'am.
Thank
Have a
you.
great day.
You too. All right, next case.
Everyone else we have is conflict.
All right, do we have conflict counsel on screen? Okay. I guess we have to wait for conflict counsel to appear. In the meantime, Miss Champion, is it possible to reach out to Miss McLeod, Mr. Murphy, or Miss Zakia Watson Cafe, or?
Mr. Murphy, this morning, Your Honor, we're waiting for a response from him. Ms. McLeod is still on leave.
Oh, Miss McLeod's back. She came back yesterday.
I'm gonna reach out to her, Miss Champion.
Okay, all right. So while we are waiting, I can just do a quick review of the Mr. Dodd, we did have announcements. I'm so sorry. I completely missed that. Okay. So on Javon Adams, position 1 is a possible plea, correct?
Yes, Judge. I communicated the recommendation to him last night, Judge. He was going to let me know what he wants to do this morning, but he's
Okay.
not informed yet.
All right, and we're going to be addressing not only this case, but does he have another case?
It is, as part of the plea bargaining, Judge, the state is going to move to null pros, the second case, assuming it's going to be a plea, Judge.
Understood. Okay, thank you. Kalen Akins is going to be a bond hearing. Is that still how it's proceeding?
I'm not sure, Judge. I sent an email late last night or early this morning again to Mr. Rhodes. We're either going to work it out or it's going to be a very brief bond hearing, Judge, and I can address the court at that point.
That's perfectly fine. I'm not going to keep you to this list. You're more than welcome to change anytime.
All right,
Okay.
thank you.
Position 3 is going to be reset to SAP on October 2nd. Position 4, Berry is a waiver of arraignment, and that's going to be further notice for trial. Imani Brown is going to be a plea. Deontay Carr was released. Positions 7 through 9. This is going to be Sade Collins, and this is going to be a waiver and further notice for trial. And then I have position 10, Calvert, who is reset to SAP October 2nd. And then I have Fountain, 11 to 12, and that's going to be a bond hearing. Paul Forias, that's
I-
the question mark, right?
I need to speak to him, Judge.
Okay.
He's not-
Joshua Goyer is a possible plea.
It's actually gonna be a negotiated plea, Judge. The state and I have a new recommendation, but it is gonna be a plea, Judge.
Okay, thank you. Hampton is conflict, and that is with Miss McLeod. McKeel Harvey is a need to speak to. 17 to 18, Hudspeth, and he was released. That brings us to Henderson Lorenzo, who is going to be, and who's conflict counsel for Lorenzo Henderson? Do we know?
Your Honor, I'm not sure, on him, Judge, only because I sent
He said McLeod.
McLeod.
Okay, we'll say possibly Miss McLeod, because I did appoint a few from a couple of C calendars 2 weeks ago, so we'll see. Shanquella Howard is going to be a plea, so is Keon Kendrick, and Lalusa is a need to speak to. That brings us to Matthews, who was a plea. McLeod, that's position 25, and that's a need to speak to. Then 26 was Olivia Moss. Has that been transferred to the DA's to Superior Court, Mr. Rhodes or Mr. Scirocco?
That has, Judge, and I've sent the order for your signature.
Okay, so this is transferred to Superior Court. Cortez Moyhan is going to be conflict as well, and that's Dennis Murphy. Darius Owen, 28 and 29, that's a waiver of arraignment, and that's going to be further notice jail jury. Position 30, Miss Tucker, if she's on Zoom, I don't know if this is going to be an interpreter case, but that's a need to speak to. Larry Riley is reset to SAP on October 9. Marcus Sims is a possible plea. Donald Smith is conflict. And that's position 33. And we don't know. Oh, this one was, well, have we already assigned a conflict counsel for this one? Is anyone, Miss Champion or Miss Grace? Don't know yet? Okay, we need conflict on this one.
It's Dennis Murphy, Your Honor.
Mr. Murphy? Okay, thank you. Janice Smith, and she's going to be a plea. Kirk Thomas is going to be a plea. Robert Thomas, oh, okay, I'll wait for Mr. Spisman. Do you know if Mr. Spisman filed a waiver of arraignment in this case?
No, Your Honor, he did not. I just sent him the Zoom, so he should be signing on shortly.
Okay, thank you. And that,
Honor Robert Thomas is escorted to downtown court today, so he won't be here.
who, Robert Thomas?
Yes,
Oh, well, and you're certain that he won't be in the courtroom today?
not in this courtroom, he's downtown.
Okay, I'm going to reset him to SAP, which is going to be, is it October 2nd? If he's not available today, but we'll wait for Mr. Spisman. Mr. Spisman may be downtown with him, so. All right, Anthony Tolbert is a plea. Tisha Tucker is a need to speak to, as well as position 40, as well as position 41 is a case has been arraigned, and that's going to be further notice for a bench trial. 42, Christopher Woods is represented by conflict. And then I have add-on position number 1, Dizana Mason, and that's a need to speak to. And Mr. Haddad's representing Brianna Nash, and that's going to be a possible plea.
Your Honor, on Ms. Nash, there's no, she was last on the calendar on the 11th of September, Judge. I don't have an offer, but by now it's a time served sentence, Judge. I expect the plea. And I just emailed Mr. Sirocco about the no further violent contacts issue. The alleged victim, just so the court is aware, is on Zoom right now.
Okay. Mr. Scirocco, Mr. Rhodes, do either one of you have Brianna Nash?
I do, Your Honor, and I just responded to Mr. Haddad with respect to the no further contact. That's what we'd be asking for. It's two cases involving the same victim here. So if we want to go non-negotiated on it, we absolutely can. But the offer is the same as it was from the 11th, and just forward that to Mr. Haddad as well.
And Mr. Haddad, do you know if Miss Nash is at ACDC?
She is, Judge. I saw her
Okay.
yesterday.
So the individual by name of Javon, we won't address Miss Nash until she appears on the Zoom session from a location called Fulton ACDC. Ah, Mr. Murphy. Good morning, Mr. Murphy.
Good morning, Judge.
All right. We've got a couple of cases for individuals who are in the courtroom. And can you tell me who are your clients that you are addressing today?
Judge number 33, Donald Smith.
Okay, Donald Smith. And is Donald Smith in the courtroom?
Yes,
Judge, I was hoping to speak to him first. I believe that there's a possibility of a plea on that one.
Okay, and do you have the plea offer from the state?
Yes, I do. I do.
Okay. All right, Donald Smith, please stand up. Okay. You would need, Deputy, we need to put him next to a phone so that Mr. Murphy may speak with him. All right, thank you. Ms. McLeod, good morning.
Morning, Your Honor.
All right, you had a couple of cases, I think, on our calendar. So let me go to the ones where I did see your name first.
Yes, Your Honor, and I would need to speak with my clients. I also need a copy of the offers. I wasn't sent a copy of the calendar
Okay.
with the offers.
All right, first one I have is Ronald Hampton. So, Mr. Rhodes or Mr. Scirocco, if you have the offer for Ronald Lee Hampton, is Mr. Hampton in the courtroom?
yes, yes.
All right, I guess we need to line them up so they can speak with their counsel. And let's start with that. Mr. Murphy with his client and Ms. McLeod with Ronald Hampton. In the meantime, I will move forward to ACDC. Deputy, I'll let you make that arrangements for them to speak with their counsel. Ms. McLeod, Mr. Murphy, y'all will need to call the jail courtroom to speak with your clients.
Yes, Your Honor.
All right, thank you. ACDC, do we have Francois there or Deputy Milton? I can't see. Oh, there she is. Good morning, Deputy Francois.
Judge, whenever you're ready, I have position number 34, Ms. Janice Smith.
Okay, all right.
Hope you're doing well.
I'm doing good, thank you. So I hope you're doing too. Let me go ahead and address the folks at ACDC. Good morning. My name is Judge Law, and we're going to be addressing each of your cases on a one-on-one basis. I first want you to remember that you have a right to remain silent. Anything you say or talk about the facts of your case, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. So we are going to begin with, was that 34? Janice Smith?
Yes, Judge.
Okay. Ms. Smith, your case number is 25 CR 5563G. In that particular case, you are accused of criminal trespass at an Amoco gas station from September 12th, 2025. You've been advised of your right to remain silent, and your attorney is Miss Tucker. Do you see Miss Tucker on the screen? She's going to wave her hand at you. Do you see her? Miss Smith, do you see your attorney on the screen? You need to tell me yes or no if you can see your attorney.
Yes, ma'am, I see you.
Okay, good. And Miss Tucker, this is going to be a plea, correct?
Yes, Your Honor.
Okay.
All right. Miss Smith, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
You need to speak louder.
Yes, I do.
Perfect. Thank you very much. Mr. Scirocco, what's the recommendation for Miss Smith?
Yes, Your Honor. For Ms. Smith on the criminal trespass, the state's recommendation is 12 months, serve 40 days, credit for time served 14 days. That is from the 12th of this month to present. Balance probated. Stay away from the Amoco gas station at 1270 East Point, 40 hours community service. She should, I believe, already be undergoing BHET on different probation. That was set back in April 22nd of this year on two different groups.
Okay. And Miss Tucker?
We do so stipulate, for the purpose of the plea, Your Honor.
Right. Miss Smith, have you consumed any medicine or alcohol recently? Miss Smith, I'm going to ask you some questions. This is Judge Lal. Can you hear me?
Yeah, I can hear you.
Okay. I'm going to be asking you some questions, and you need to answer honestly so I can decide how to proceed with your case. Yes or no?
Yes, ma'am.
Okay. Do you understand what you are doing today?
I'm at court.
What?
She said she's in court.
I'm here
All
my
right.
hearing.
Do you know what you are charged with?
Ma'am,
Do you know what you are charged with? What's the charge against you?
trespass,
Where?
Amoco.
Okay. And
Bartlett.
you have spoken to your attorney, Miss Tucker, correct?
Correct. It's already been done.
Okay. So I'm
It's
going to
already-
I'm going to ask you a bunch of questions, and if you don't understand, you need to say I don't understand, okay?
Right, okay.
Have you consumed
Okay.
any medicine or alcohol recently?
I'm not,
Sit up close to the computer and answer the question.
yeah, I go.
Have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what is going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am, I am. I am satisfied with my attorney.
If you are pleading guilty to the charge today, are you doing so freely, willingly, and
Yes,
knowingly?
ma'am.
So you understand that if you plead guilty, you will not have a trial. You will not go to a courtroom. You will not face your accuser, and the prosecutor won't have to prove the charge beyond a reasonable doubt.
Yes,
Are you
I'm-
prepared?
I'm-
Are you prepared to give up these rights?
Yes, ma'am, I do.
How do you plead to one count of criminal trespass?
Guilty. Yes,
Your sentence is 12 months to serve 40 days, credit for time served 14 days. You have 7 more days to serve at the jail.
that was more. Well, she said 6, but, I really I take the 7 and talk to you. She said 6.
I may have miscalculated.
It is 6, Your Honor.
6. I'm so sorry. My numbers it's 6 more days.
Yes,
So that's good. That's good because you understand what's going on more than I do. That's better.
you the judge, you are.
No, I make mistakes. I'll be the first one to own up to it. Okay. And then once you finish the 6 days, you will be on probation. While you're on probation, you would need to do 40 hours of community service. And you need to do this voluntary service at any nonprofit agency, but it cannot be a church and it cannot be a school.
Do it each part.
I don't understand what you're saying.
Fine. I do it what I said.
What was that?
I would do it in each front. I would complete my
You will do the community service?
I'm trying to. I got the rod in my leg and feet. And really, I can't hardly. Wow.
Well, you need to do somewhere where you can sit down and take care of it. But that is the recommendation, that you need to do 40 hours of voluntary work. You don't have to be standing up to do it.
Okay.
You just need to
All
find
right.
somewhere where it's a sit-down job.
Look, I'll go do the community service at each front. I'm doing it each front.
Francois, I don't understand what she's saying. What is she saying?
So she stated that she's gonna do her community service at East Point.
At East Point, that's fine.
I'm doing it.
And you report to probation once a month? You understand that you also have another probation case where you need to comply with all the conditions.
Okay.
All right, that completes your sentence. Thank you. Oh, and you need to stay away from the Amoco gas station. If you go back there, you'll be arrested again. Thank you.
Okay, well, yeah, I'd rather go ahead and go to that.
All right.
Your Honor, I have an announcement on position 39 and 40. Those will be pleas as well. And add on position 2, Ms. Mason will be a waiver.
Why not? Huh?
All right. Dizana Jane Mason is a waiver, and her case is going to be further noticed for jail jury. Thank you.
Number 1, Mr. Javon Adams.
Javon Adams is accused of 3 counts of simple battery family violence, case number 25 CR 5523F. He's got another open case, 24 CR 6995F. And with respect to both these cases, Mr. Adams, you've been advised of your right to remain silent. Your attorney is Mr. Haddad. And I understand that this is going to be a plea to the case from September 6, 2025. And if the plea offer goes through and the plea is well, then the state will consider a dismissal of the prior case.
No.
So, Mr. Haddad, is your client moving forward with this plea?
Yes, it's a negotiated plea, Judge.
All right. Mr. Adams, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? You need to speak up louder.
Yes, ma'am.
Thank you. Mr. Rhodes, what's the recommendation for the 3 charges?
Yes, Your Honor, as it relates to the count 1 is 12 months to serve 60 days in jail, credit for time served, balance on probation. We're requesting 24-week family violence intervention program. He's to have no further contact with the victim, Ms. Sybil Gill, and to stay away from 998 Redford Drive in Southeast Atlanta. Count 2, it is the precise same recommendation, Your Honor, to run concurrent with count 1. And as it relates to count 3, it is the precise same recommendation to run concurrent with counts 1 and 2. And the state will, upon acceptance of this guilty plea, enter for the court today a null pros on open case 24 CR 006-995F. If we can send that to you, Your Honor, we will. Or if we have to send it to the division, we will as well.
Yes, please send it to Miss April Champion, the
All
null pros. All plea paperwork goes to her directly today.
We'll do it.
All right, and the credit for time served according to the jailing screen is 14 days. Is that correct? Or is there any other?
That is correct, Judge.
All right. And he's got a pending DUI case as well. One, two, three. Okay, and Mr. Haddad, do you so stipulate?
We stipulate for purposes of the plea, Judge, I would ask the court to consider waiving the first 2 months of probation fees, Judge.
On what grounds?
Judge, honestly, just in terms of, I mean, he's gonna end up having to serve 30 days, Judge. He's gonna start back out with employment, the cost of the classes, Judge. You know, he's got due 24 weeks. We're just asking for those first 2 months so he can get back on his feet, Judge.
I will waive 1 month.
That's fine, Judge.
Just given his recent arrest record, this is not an issue of being indigent. This is just an issue of reoffending frequently. So this is just a waiver of 1 month, and he's already getting his prior case dismissed. So I think he's got enough bonuses right now.
Understood, Judge.
All right, Mr. Adams, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case? Yes, no?
Yes, ma'am.
And are you satisfied with your legal services by Mr. Haddad?
Yes, ma'am.
If you decide to enter this guilty plea, are you doing so freely, willingly, and knowingly?
Yes, ma'am.
And you understand that by pleading guilty to these charges, you would have to give up your right to a trial. You will not go back to a courtroom to face a judge or a jury, to face your accuser, challenge evidence brought against you, have the assistance of counsel to present your legal defenses and arguments, and the state won't have to carry its burden and prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 3 counts of simple battery family violence?
Guilty.
Counts 2 and 3 will run concurrent with count 1. For count 1, the sentence is going to be 12 months to serve 60 days. Credit for time served 14 days. So you have additional time to serve at the Fulton County Jail. Once you have completed the additional time, you will report to Fulton County Probation within 48 hours of being released. While on probation and within 30 days of being released, you will enroll in a domestic violence intervention program, which is a series of 24 classes, and you will attend and complete all classes without missing or skipping them, and you would need to pay for those classes out of your own pocket. You will also stay 200 yards away and have no contact with Sybil Gill. You're not to be within 200 yards of her, and you're not to communicate with her in any way, form, or manner, including mail, email, third-party, phone, computers, and even on social media. You're also required to stay 200 yards away from 998 Redford Drive in Southeast Atlanta. You will report to probation every month. Your first month of probation fees shall be waived. And at all times, you're not allowed to consume any alcohol. You're not allowed to consume any illegal drugs. And you're not allowed to own or possess any firearms. You will be subject to random screens for illegal drugs and alcohol by probation. If you get arrested again, or if you violate any of these conditions, your probation will be revoked and you will serve out the rest of the year imprisoned. Upon completion of this, I guess the state will null pros, in other words, not prosecute you for the earlier case, 24 CR 006995F. Thank you.
Thank you, Judge.
How much time I got left? 16 days?
Next, Judge, I have position number 40, Kayla Ward.
Okay. Kayla Ward is accused of theft by shoplifting and willful obstruction of an officer from September 9th of this year, case 25 CR 5552F. Ms. Ward, you've been advised of your rights, and your attorney is going to be Ms. Tucker. May I place you under oath? Please raise your right hand.
Aye,
Yes.
Judge. Cup to the back, Judge.
Okay, all right. We're going to constructively place you under oath. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Speak up, please. Can't hear you.
Yes.
Excellent. That's the volume I want to hear. Mr. Scirocco, what is the recommendation for Ms. Ward?
Yes, Your Honor. On the count one, theft by shoplifting, state's recommendation is 12 months, served 32 days, credit for time served 16 days, balance probated, anti-theft course, $500 fine, stay away from the Walmart located at 844 Cleveland Avenue, Southwest and East Point, and count two, the willful obstruction, 12-month probation concurrent with count one, $300 fine. We would ask the defense stipulate the factual basis, venue, and ID for purposes of the plea.
We do so stipulate for the purpose of the plea. And Your Honor, we would like to request from the court that the $300 fine for the willful obstruction charge be converted into 30 hours of community service. And once all the terms are complete, that her probation go to non-reporting status.
Mr. Scirocco, how much credit time are you giving her? I'm sorry, those aren't listed on the recommendation, so
Oh, she would receive 16 days credit, Your Honor.
16
from
days.
September
Okay.
10th to present.
Okay. I'll amend the $300 fine to 30 hours of community service, but she understands that she has the $500 fine from the shoplifting charge to pay. Okay. And do you so stipulate, Ms. Tucker?
We so stipulate, Your Honor.
All right. Ms. Ward, I'm going to ask you a few questions, and please remember to speak up so that you can be heard for the court reporter. Have you consumed any medicine or alcohol recently? Did you hear that, Ms. Greenhouse? All right. We can't hear you, Ms. Ward.
No.
Good. And have you understood what's going on in your case?
Yes.
Are you satisfied with your attorney?
Yes.
If you decide to enter a guilty plea to these charges, are you doing so freely, willingly, and knowingly?
Yes.
Please understand that you would have to give up your right to a trial. You won't be able to face your accuser, challenge the evidence brought against you in a court of law, be able to present your own defenses and arguments, and the prosecutor won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to theft by shoplifting and willful obstruction of an officer?
Guilty.
Your sentence for the theft by shoplifting is to serve 12 months. 12 months to serve 32 days. Credit for time served 16 days. Once you have, I guess you'll be released within 24 hours if you have no holds at the jail. And you will report to Fulton County Probation on Monday before 3 p.m. While on probation, you will enroll and complete an anti-theft class, and this must be done within 90 days of being released to probation. You will also pay a $500 fine, and you will make those payments at a minimum rate of $50 per month, including plus your probation fees. At all times, you will stay away from the Walmart store at 844 Cleveland Avenue in East Point, Georgia. With regards to the obstruction charge, it's going to be 12 months concurrent with count one, with the addition of 30 hours of community service at any nonprofit agency except a church or a school. And you will do your community service at a minimum rate of 5 hours per month. That concludes your sentence. Thank you.
Your Honor, I did make a request for her to be allowed to go non-reporting once the term.
Denied.
Yes, Your Honor.
We could do number 18, Mr. Hampton. He's a convict. Come on, sir.
Hampton, okay.
Judge, you were done with position 40?
Yes, we completed. Did y'all hear it all? Oh.
Not.
Can you hear me all
What did
right?
you say about now?
Hang on.
Yes,
Let
Judge,
me-
I was asking, are you?
Let me just change my audio and see if there's. Can you hear me all right, Francois?
Yes, I can hear you, Judge. I was asking, are you done with position 40, Ms. Ward?
Yes. Did y'all hear the entire sentence?
The last statement, Judge, we didn't catch that.
She has to report to probation every month. There is no non-reporting.
Okay, perfect. Thank you, Judge.
Thank you. All right, who is next?
Number
Mr. Hampton, Your Honor. Good morning.
Good morning. Okay. We have State versus Ronald Lee Hampton, accused of battery and simple battery in case 25 CR 5124J. Mr. Hampton, you've been advised of your rights, and your attorney is Maureen McLeod. Ms. McLeod, how are we proceeding in this case?
Your Honor, this is going to be a negotiated plea this morning. My client also would like to find out whether or not he has any holes. I did not see any, but of course, my access is not as extensive as the state has.
Let me see. I only see these two charges. His prior charges, he was released. Most of his prior charges were NOD'd. He doesn't appear to have any holes in this county, and there are none from any other jurisdiction. So I think I'll just say no.
Thank you, Your Honor. He is interested in the state's plea officer. This is going to be a negotiated plea.
All right. Mr. Hampton, please raise your right hand.
Yes,
Do you
ma'am.
do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Rhodes, what's the recommendation for Mr. Hampton?
Yes, Your Honor, on position 1725 CR 004-708F. The recommendation for count one is 12 months probation, credit for time served, 12-week anger management, and no further contact with the victims. They are Tamaria Smith, and Kamaya Harris.
Are we addressing Ronald Lee Hampton?
I'm sorry,
Position 15.
15. My apologies. I was on position 17.
Oh, no.
I apologize.
No, that's okay, but position 17 for was released, so I'm sure he's happy to hear that. All right, so whenever you're ready, we'll go back to Mr. Hampton.
All right, thank you. 25 CR 005-124J for Mr. Hampton.
Yes.
The recommendation on count one is 12 months probation to serve 60 days, credit for time served, balance on probation. He's to have no further contact with Mr. Ryan Hughley, the victim in this case. We're asking for a 12-week anger management. We're asking that count two merge with count one.
Okay. And any objection to amending it to 12 months to serve 58 days because he's served 29 days?
No objection, Your Honor.
All right. So 58 days, credit for time served, 29 days. Okay. And Ms. McLeod, do you so stipulate with regards to count one?
Yes, Your Honor, we do so stipulate for purposes of the plea.
Okay. Mr. Hampton, have you consumed any medicine or alcohol recently?
No, I just take my psych medication.
All right.
Codeine.
And after consuming that, are you still able to understand your attorney and your case?
Yes, ma'am.
And are you satisfied with your counsel?
Yes, ma'am.
And are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
So you understand that you would have to waive your right to a trial. You will not go back to court to face your accuser, be able to challenge the evidence brought against you in this case, to confront your accuser, and the prosecutor won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am. Yes, ma'am.
How do you plead to one count of battery?
I plead guilty.
Count two, simple battery, will merge into count one. For the battery, your sentence is going to be 12 months to serve 58 days, credit for time served 29 days, balance probated. You'll be released within 24 hours, but you must report to the Fulton County Probation Office on Monday before 3 p.m. While on probation, you will complete 12 anger management classes, and you must begin those classes within 90 days of being released, and you cannot miss or skip any classes. You're also to have no contact with Ryan Hewley. Once you have completed all your anger management classes and you're up to date with your probation fees, your probation may be non-reporting. Thank you.
Thank you, Your Honor.
All right. Next case, please.
Right there.
Judge, I have, this is gonna be on the add-on calendar, position number 2, Ms. Nash.
Okay, she's position 2 and 3. Ms. Tucker, that would be Mr. Haddad's.
Yeah.
Brianna Nash has 2 cases before the court, 25 CR 5401J, and in which she's accused of simple battery, family violence, and willful obstruction of an officer from September 3rd, 2025. Her second case is 25 CR 4377J. She's accused of simple battery, family violence, and battery, family violence from August 1st of this year. Ms. Nash, you've been advised of your rights, and your attorney is going to be Mr. Haddad. Mr. Haddad, how are we proceeding?
Your Honor, it is, I don't have my notes right in front of me. It's going to be a non-negotiated plea as far as the, our request for a no further violent contact. The victim is online, Judge. The parties were living together. They have a child together. They are facing an eviction procedure. So anyway, my point is that it's non-negotiated as far as the no contact. Now, I have to do my math real quick, and that's where I've left my notes. But my understanding was it's a time served sentence. That was the recommendation back on this September 11th was for additional time. But by now, I believe she would have served the 30 days.
And what's the name of the alleged victim?
Judge, it's Javon
Clinton,
Judge, and
I'm sorry, was it Fulton or Clinton?
Clinton.
Clinton. All right, Mr. Clinton, you would need to start your video and unmute. All right, raise your right hand. Do you solemnly swear and affirm, Mr. Clinton, that the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right, this is Brianna Nash, accused of 1, 2, 3, 4 violent charges involving you as a victim, I believe, in both cases. I can't really recollect, but I think you were the victim in both cases.
He was, Judge, or he
All right. So, Mr. Clinton, the Public Defense Counsel is arguing that she should be allowed contact with you. Do you agree with that statement?
I do agree.
Okay.
I would like to add just no further violent contact, but as far as no contact, that just sounds like
Why no violent contact? Why?
that would
Convince
just
me
be
that
the
she
only.
should convince me that she should have non-violent contact with you.
Non-violent.
Yes.
We stay together and we have a child together.
That doesn't mean anything. She's got 2 violent cases against you, involving you as the victim.
I understand that, ma'am. This is a situation where we just have to get going as a family as far as her medication. So once we get her on her medication, she'll be perfectly fine. Like, it's not that she's a violent person. This is just what happens when things are not going right. Just like I said, we have a eviction on the 30th, so it is a lot of stress on her and me as well. So she's not a violent person. This is not what she is. This is not who she, what she normally does. It's just unfortunate circumstances, and we all have had those in our life. So that's why I say, no further contact would just not make sense because we're trying to move forward as a family.
Okay. All right. Thank you so much.
problem.
Mr. Scirocco, what is the recommendation for position 2?
Your Honor, since this is non-negotiated, where's the, excuse me, position 2 would be, okay, that's
On the
25
add-on
CR.
calendar, I'm sorry, on the add-on calendar.
Gotcha. Thank you. Thank you. That incident was from August 1st of this year. That's at their shared living space at 565 Wells Street in Atlanta. The officer made contact with the victim, Mr. Clinton, who explained that the defendant, mother of his child, had poked him in the chest with a pair of scissors, causing a laceration that the officer observed. Now, the difference between poked and stabbed, I'm not quite sure, but concerning nonetheless. The second incident from September 3rd for position add-on 3, this was subsequent to receiving a bond on that first case, wherein she was given the condition not to have any further violent contact with Mr. Clinton. She was screaming belligerently that she wanted a male in the home gone, as well as his child. Mr. Clinton, to the police, explained that the defendant busted into the bedroom, and he and another individual, presumably a juvenile JN, they were asleep and they got into a verbal dispute. The officer was shown footage by Mr. Clinton from his phone of the defendant screaming at him, raising her hand and striking his hand, the one that was holding the phone. And the recording device tumbles to the ground, shows the strike coming in. So she's shown she can't abide by no further violent contact, which is why we'd be asking for no further contact. When the officer approached Miss Nash to detain her with handcuffs, she pulled her wrists from the officer, ran from the residence, and the officers gave chase. There was continued struggling, and she said, "I'm not going back to jail." And they were eventually able to detain her despite the resistance. So the state's recommendation is on add-on position 2, on the simple battery, family violence, and the willful obstruction. I apologize if I mixed up the order here, Your Honor, but the simple battery, family violence, willful obstruction, count 1, the simple battery would be 12-month probation concurrent with 25 CR 004377J. No further contact with Javon Clinton. Stay away from 565 Wells Street, Atlanta. Count 2, the willful obstruction, 12 months probation concurrent with count 1, $300 fine. On the other case here, docketed to 25 CR 004377J, the simple battery, family violence, and battery, family violence. Count 1, the simple battery would merge with count 2, and the battery, family violence, count 2 would be 12 months, served 60 days, credit for time served. Now, what I see for credit for time served for that is 25 total days. So there would be additional time to serve. That is from August 1st of 2025 to the 2nd, and then from September 3rd, 2025 to present. So that would be 25 total days, credit for time served. Balance probated, complete FFib, ADET, MHET, no further contact with Javon Clinton, stay away from 565 Wells Street in Atlanta, and 60 hours community service. We would ask that defense stipulate the factual basis, venue, and ID for purposes of the plea, and that is all for the state. There is a diagnosis here, but the issue seems to be not taking medication, and also self-medication with drugs and alcohol. So.
And with regards to the add-on position 2, this was 12 months to serve how many days, credit for how many days?
Could you read the case number for me? I apologize. I don't have the
25 CR 005401J.
That would be 12 months probation concurrent with the other
Okay.
case. Yep.
I see. Got it. Okay.
Your Honor, if I'm-
Right. Mr. Haddad, what is your position with regards to, was it just the no violent contact with Mr. Javon Clinton?
Judge, additionally, the time served portion, and that was my fault, Judge. I was looking at the August 6th date, not the September 3rd. So I would respectfully request the court to sentence her to 46 days with 2-for-1, essentially time served and no further violent contact. Now, as far as Ms. Nash, Judge, obviously it appears that there's some mental health component. These two cases were back to back. Mr. Clinton actually was the one that reached out to initially the clerk's office because he wants to get her out. He wants her back home. The child in question is fairly young. I can't remember right offhand how old the child is.
She is 6.
And I mean, under the circumstances, I understand, but I mean, I believe it would be obviously more egregious had she pled guilty to one case, gone out and then recommitted a new offense. Under these circumstances, Judge, in light of what the victim has mentioned to the court, I believe it's more appropriate sentence for a time served and no further violent contact, Judge.
Okay,
Could I speak?
sure.
I agree with him. Credit for time served. Just like I said, we have a court date on the 30th, to where we have to answer for an eviction. Now she was the only one that can actually answer for that because she's the only one that's on the lease, at the moment. As well as I understand, the problem with the violent contact. But this is actually her residence. So it just would be it just doesn't make sense that she can't come back to her own home. If anything, I guess I would leave. But I just don't see why she, shouldn't be able to, come to her own home.
What's that dispossessory case number?
Could you repeat? I didn't hear you.
What is the eviction case number?
I do not have it, but it is in the system. Everyone has seen it.
Mr. Clinton, I need it because I want to know why they're evicting both of you, because my guess would be because of these 2 incidences of domestic violence at the property.
No.
I need to see the case.
I do have the case right in front. I don't have the case number, but I have like the paperwork, but I don't really have, I don't know
Case
what
number would either be 25 DD or it would be 25 ED.
Oh yeah, okay, I do have it, yeah. But it's not for what's
I
going
don't
on.
want to hear, I want to read it myself. What's the
Okay,
case number?
25 ED 355877.
Give me a moment.
No problem.
All right, your hearing is scheduled for September 30th, 2025 at 1 p.m. in courtroom 6G in Magistrate Court. Eight 12. All right, this was filed on August 12th, so it was before the second case, and this is for failure to pay rent. All right.
Yes, ma'am.
Your Honor,
Mr.
it appears on the what I'm looking at here in the dispossessory answer, it states she does not have a landlord-tenant relationship with the plaintiff.
That's just
Yeah.
her defenses, and they can take it up
All right.
in dispossessory court. All right, Mr. Haddad, I will amend the time served, so it would be 12 months to serve 50 days, credit for time served 25 days. Would that be acceptable?
Yes, Judge.
All right. I will amend the no further contact to no violent contact. And for the first 6 months that she is on probation, she will report twice a month, although she will only pay probation fees once a month. She will also be required to enroll in a mental health program within 30 days of being released, and she must be compliant with all treatment and all medication. Miss Nash, if you don't want to do that, I'll be glad to reset both cases for trial. This is just my recommendation. You don't have to accept it. And you definitely can go to trial, and if the state if the state does not prove the charges against you beyond a reasonable doubt, these charges will be dismissed and you can carry on with your life. Today, if you decide to plead guilty to battery, family violence, and in the future, if you are charged again with such an offense, it will be a felony charge, and you will be in jail for much longer time, and your bond will be much higher. So I want you to understand the consequences if you decide to plead guilty today. So this is my recommendation. Mr. Haddad, would you like to confer with your client?
I think we've discussed it. Ms. Nash, do you wish to plead guilty? You need to speak to me some more. It's up to you, ma'am.
Ms. Nash, you need to answer your attorney. Do you want to speak with your attorney, or would you like to continue with the plea? Speak up.
I would like to continue with the plea.
Okay. So you understand that you'll be, for the first 6 months while you're on probation, you'll be reporting twice a month.
Yes, ma'am.
And no violent contact with Javon Clinton and your family, including your child, means there cannot be any future physical altercations. Well, if you're rolling your eyes at me, I'm not
rolling my eyes at you.
Ma'am, I can see you on my big screen. All right. So every movement you make, I can see it clearly because your entire face is on my monitor. Now you need to look at me again. No violent altercations means there cannot be any physical altercation, no hitting, no stabbing, no poking with scissors or any kind of weapon. There cannot be any verbal altercation. You cannot argue with him. You cannot have any disputes with him. You can have a civil argument where there's no raising of voices, no calling each other names, no profanity. But if law enforcement gets involved again with any kind of altercation between the two of you, the first person they're going to believe is him, and the second thing they're going to do is have you arrested. Do you understand?
Yes, ma'am.
All right. As long as you understand that. So, Miss Nash, have you consumed any medicine or alcohol recently?
Yes.
And after consuming, all right. Francois, does she not understand me, or can she not hear me?
She didn't hear you, Judge. If you can repeat it again.
All right. Miss Nash, can you hear me?
Yes, I can.
Have you consumed any medicine or alcohol recently?
No.
And have you understood what's going on in your cases?
Yes, I do.
And are you satisfied with your legal services?
Yes, ma'am.
If you decide to enter a guilty plea to these 3 charges, are you doing so freely, willingly, and knowingly?
Yes, ma'am.
So you understand that by entering a guilty plea on the charge of battery, family violence, that will go on your record. And if you're ever arrested again for battery, family violence, it will be a felony charge.
Yes, ma'am.
Are you still willing to move forward willingly?
Yes, ma'am.
By doing so, you would have to give up your right to a trial. You will not go back to a courtroom to face a judge or a jury. You will not be able to confront your accuser or challenge the evidence brought against you. In addition to that, your attorney won't be able to argue your legal defenses and present that to a judge or a jury. The state won't have to prove the charges against you beyond a reasonable doubt.
Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to simple battery, family violence, and willful obstruction of a law enforcement officer from September 3rd, 2025?
Guilty.
Your sentence for the simple battery is going to be 12 months probation, concurrent with the second case, and you are to have no violent contact with Javon Clinton. And with regards to the willful obstruction of a law enforcement officer is going to be 12 months probation concurrent with count 1, and you will need to pay a $300 fine at the minimum rate of $30 per month in addition to your probation fees. As I've indicated, you will report to probation on Monday, and you will continue to report to probation twice a month until the remainder of the 12 months is over. In add-on position number 3, 25 CR 4377J, incident date August 1st, 2025. How do you plead to battery family violence?
I plead guilty, but I thought you said for the first 6 months I report twice.
No, ma'am. For the first 6 months, you report twice a month. After that, you can report once a month. That's what I mean. Okay. As I've asked, how do you plead to battery family violence from August 1st, 2025?
Guilty.
Your sentence is going to be 12 months to serve 50 days, credit for time served 25 days. You will be released within 24 hours, and as I've indicated, you will report to probation on Monday before 3 p.m. Again, report twice a month for the first 6 months, and then it will be reduced to once a month. Understood?
Yes, ma'am. Thank you.
No, you're not done. Now you'll have to complete the following conditions while you're on probation. You will enroll in a domestic violence intervention program within 30 days of being released. This is a series of 24 weeks of domestic violence counseling, and you will attend and complete all 24 classes without missing or skipping them, and make sure you've timely paid for those classes. You will enroll in an alcohol and drug evaluation and submit yourself to any treatment that's required. This must be done within 10 days of being released, and you are not to consume any alcoholic beverages, and you're not to consume any illegal drugs, including marijuana, while you are on active probation. You will be subject to random screens by probation for alcohol and/or illegal drugs. Within 30 days, you will also seek out your current doctor or seek out a qualified doctor to undergo a mental health evaluation and submit yourself to all treatment that's required. You will be compliant with all medication that's prescribed to you and all treatment that's prescribed to you. Again, you are to have no violent contact with Javon Clinton, and you are to complete 60 hours of community service. You will do the community service at any nonprofit agency that is not a church and not a school. You will do your community service at a minimum rate of 6 hours per month. Any questions?
No.
All right, thank you. That concludes the plea for add-on positions 1 and 2.
Judge, I have brief announcements when you get a moment.
All right, Mr. Clinton, you're free to go.
Thank you, Judge.
Mr. Murphy, which position am I addressing?
Position 33, Donald Smith.
All right, and the announcement, sir?
Judge, Mr. Smith, after I've spoken to him twice, and he's chosen to go pro se.
Okay.
And then the second position I have is 27, Cortez Myhand.
Yes.
And that one, we're going to just take that case back to the division judge. He has other cases.
Are you filing a waiver of arraignment, or would you like me to arraign the case?
I'll file a waiver, Judge.
All right. Cortez Myhand, position 27, is going to be further notice for jail jury. And courtroom 2,
Do we have Mr. Donald Smith?
Right in front of you, Your Honor.
Thank you. Mr. Donald Smith is accused of criminal trespass causing damage to property and one count of criminal trespass involving a location at the 2139 Martin Luther King Jr. Drive location. This is from September 3rd, 2025. His case number is 25 CR 5252B. Mr. Smith, you're advised of your right to remain silent. Anything you choose to say about the facts of the case in open court, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one, you have a right to appointed counsel, such as Mr. Dennis Murphy. If you choose to waive your right to appointed counsel, then you have a right to either hire your own attorney or choose to represent yourself. Have you hired a private attorney?
No.
And if you choose to represent yourself, you are responsible for understanding the criminal laws and procedures and how they apply to the facts of your case, and that you're responsible for the impact of any legal decision that you make upon your current case, upon any open cases, as well as upon your legal circumstances. Are you choosing to waive your right to counsel?
Judge, can you tell me the name and the accusation of this charge, this case? Because it's not my public policy to assume the debt of other people. Did you know this is a public policy bankruptcy proceeding?
I'm asking you a question. Have you waived your right to counsel?
No, I haven't done anything.
Then I will reset and address your case next week until you are prepared to answer the court's questions.
You said prepare to answer the court's question.
Yes.
I'm prepared.
I'm asking you again, one last time, before I decide to reset your case. Are you waiving your right to counsel?
No.
Okay. Then we have Mr. Dennis Murphy who's representing you.
Yeah, I'm okay. I'm okay.
You're okay with what?
Not using him as my counsel.
Are you okay with Mr. Murphy being your counsel?
No.
All right. Then have you hired an attorney?
No.
Do you plan to hire an attorney?
No.
So then you're representing yourself. That leaves you with the third option. So I'm going to ask you one last time.
Third option.
Are you waiving your right to counsel and choosing to represent yourself?
Yeah, I'm going forward with what I'm saying today. Yeah.
Okay. My next question. You are charged with 2 misdemeanor offenses, criminal trespass causing damage to property and criminal trespass from September 3rd, 2025. How would you like to plead today?
Well, I can't determine, where's the contract? I can't determine anything without the contract.
The accusation, would you like a reading of the accusation? I will then arraign your case and deem your entry to be a not guilty plea.
Are you familiar with the Clearfield Doctrine versus United States?
The court will accept Mr. Smith's response as a not guilty plea. Would you like me to read the accusation, or do you want me to waive a reading of the accusation?
I'd like to see the contract. You have the contract?
This will consider a waiver of the reading of the accusation. Mr. Smith, these are the 2 misdemeanor charges brought against you. If you decide to proceed to trial, please remember that you are legally presumed innocent of these 2 criminal charges, and the state has the burden to prove the charges against you beyond a reasonable doubt. If the state prevails and overcomes your legal presumption of innocence, you could be convicted of 1 or more of these charges and be sentenced to up to a year in prison and or up to $1,000 fine for each offense. Given this information, would you like to proceed to trial, or would you like to consider the state's offer?
Like I said, I can't determine anything without the contract. Where's the
All
contract?
right. The court will accept the defendant's response as a not guilty plea. The case has been arraigned and it will be further noticed for trial.
If you plead for me, you'll be practicing law from the bench.
Deputy, we are done with Mr. Smith. Thank you.
Judge, I'm going to leave now.
Thank you, Mr. Murphy.
Position number Howard.
Howard? Okay. Okay. Shanquella Howard. is position number 20 on the SAP calendar. Ms. Howard, your case number is 25CR005547G. Ms. Howard, you've been accused of criminal trespass and possession and use of a drug-related object from September 11th of this year. You have been advised of your right to remain silent, and your attorney is Ms. Tucker. Ms. Tucker, I understand this is going to be a plea. Would that be correct?
Yes, Your Honor.
All right. Ms. Howard, please raise your right hand if you can. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Speak up, please.
Yes, ma'am.
Thank you. It's okay to speak loudly. This is just a mechanical issue. Okay. Mr. Rhodes, what's the recommendation for Ms. Howard?
Yes, Your Honor. As it relates to Ms. Howard, on count 1, the criminal trespass, the state's recommendation is 12 months to serve 30 days, credit for time served, balance on probation. We ask that she undergoes an alcohol drug evaluation and treatment. And we ask that while on probation, she stay away from 1069 Ponce de Leon Avenue, and that she receives a social work visit to determine her needs. On count 2, possession and use of drug-related objects, the state recommendation is time served.
Thank you. Ms. Tucker, do we so stipulate?
We do stipulate for the purpose of the plea, Your Honor. And we would like to request that after she undergoes the evaluation, that her probation go on non-reporting status.
Let me just see one thing. I'm going to deny the request for a non-reporting. She has been arrested multiple times between 2020, 2021, 2022, 2023, 2024, 2025, and this is her 1, 2, 3. This would be her 4th conviction for the year of 2025.
Yes, Your Honor.
Okay. So she'll be required to report to probation every month. Miss Howard, your attorney has asked me to put you on non-reporting probation. I have denied the request. You'll be required to report to probation every month. Would you still like to move forward with the plea?
Yes, ma'am.
All right. Ms. Howard, have you consumed any medicine or alcohol?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your attorney?
I'm very satisfied.
If you decide to plead guilty, this will be your 4th conviction for a criminal offense in the year of 2025. Did you understand that?
Yes, ma'am.
And are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
If you decide to enter this plea, you would have to give up your right to a trial. You will not go back to a courtroom to face a judge or a jury, not be able to face your accuser. Your attorney won't be able to present your legal defenses and arguments, and the prosecution won't have to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am, I am.
How do you plead to 1 count of criminal trespass and 1 count of possession and use of a drug-related object?
Guilty.
I'm sorry?
Guilty.
On the criminal trespass, your sentence is going to be 12 months to serve 30 days, credit for time served 15 days. The remainder of your time you'll be on probation, which you will report every month. While you're on probation, you will undergo an alcohol and drug evaluation within 10 days of being released, and you will submit yourself to any treatment that's required. You will not consume any alcoholic beverages, and you will not consume any illegal drugs, including marijuana. You will be subject to random screens by probation for alcohol and or illegal drugs.
At all times, you're required to stay away from 1069 Ponce de Leon Avenue. And if you return to that location, you'll be arrested again. Before you are released, you'll need to have a visit by a social worker in order to understand your housing needs. With regards to the possession and use of drug-related objects, your sentence will be to serve 30 days, credit for time served 15 days. That will be time served. Please remember to report to the probation office on Monday before 3 p.m. and keep a list of when your next appointment is at all times. Thank you.
We can do, position number 42, Mr. Wood.
42, okay.
That is Miss McLeod's case. Are you here, Miss McLeod?
She is.
All right.
Hang on, I'm just waiting for it to
I'll wait.
appear on screen.
Yes, I'm here.
All
I'm
right.
sorry, I was
No, no.
clicking, it wouldn't come on.
No problem. All right. So we are addressing position 42. This is State versus Christopher Woods. Mr. Woods is accused of simple battery family violence from the 12th of September this year, 25 CR 55671. Mr. Woods, you've been advised of your rights, and your attorney is Maureen McLeod. Ms. McLeod, how are we proceeding?
Your Honor, the state did not give me an offer on this case because they are seeking a continuance so that the case can be sent up to see whether or not it is a felony. I have spoken to my client concerning that, and we would like to proceed with a non-negotiated plea if the court is inclined to address that.
All right. So right now, Mr. Woods has got a $2,500 good bond for this case, simple battery family violence, from September 12, 2025. He's got another open case, and that is 25 CR 005568Y. And he was previously, no, this was another case for simple battery family violence, same date. And he was given a signature bond through pretrial services level 1. So are we doing a plea on just the 567 case, or are we going to be addressing this other case?
Your Honor, I haven't seen the other case yet. I will look at that in a second, but with respect to this case, we were waiting on subsequent documentation with respect to victim injuries here. The state has subsequently filed down an amended accusation. There were typos on the original simple battery family violence, as well as an added accusation for battery family violence. It's been sent. It's been filed. So there is an additional charge to be dealt with here. With respect to the present case, with it being a battery family violence, we are seeking a 1-week reset. We see there's a prior of the defendants. It was 2 charges with a battery family violence merging into an aggravated assault from 2017. So we are seeking a reset so that we can get the documentation to confirm that aggravated assault is in fact aggravated assault family violence with respect to recidivism here. So that would be the state's position.
All right, and you are filing the amended accusation in the case ending in 567?
The present case, and again, that is the instant case on the calendar, Judge.
Correct.
It has been filed.
Okay, was it today?
Yes.
Okay, so it's just not uploaded. So I just want to let y'all know that he's got that second case. All right, Ms. McLeod, your client actually has 2 cases, one with the signature bond through pretrial, and the other one, he's got a $2,500 good bond. And the state wants to consider an upgrade to a felony charge.
I understand, Your Honor.
But there's no offer for, so what you're saying is that this is going to be strictly an offer from the defense to consider
a reduction without, and of course, I'm assuming the state's going to object to anything you ask for.
Yes, Your Honor. Now, I was unaware that it was two open cases. I thought there was just this one.
Well, it's there.
Well, it would have to be a global offer for these two cases. I would not want him to negotiate one without the other because that would mean he would just continue to sit if he's unable to post the $2,500 bond.
All right, so
For
we
the
will
other
reset this case to October 2nd, and
Yes.
we will also reset the other case. Ms. Champion, that other case is 25 CR 005568Y. And we
And
will,
I believe he has a question. He seems a bit confused too as to what is going on with these cases.
Your Honor, that second case is showing up as a co-defendant case. That defendant is
oh, I'm
Mary.
sorry. Yes, it's Mary Batson. I do apologize. I didn't, it was just listed. It's Mary Batson. Is that the cross defendant?
Yes, Judge.
Okay, I'm so sorry. I
That
just
would-
pulled
that
it
would
up
make
and-
sense.
Okay, yeah, I'm so sorry. The style of the case at the top was blocked by my screen. I apologize. So disregard what I said about the second case. Do you still want to move forward with your non-negotiated plea offer, Ms. McLeod?
Your Honor.
All right. Mr. Woods has been advised of his rights. You may proceed, Ms. McLeod.
Yes, Your Honor. I thought that he could do a time served plea. That was what we were hoping for because he wants to get out of jail.
Well, I'm sure everybody there wants to get out of jail. He's been in custody now for 3 days, according to the jailing screen.
No, Your Honor, he's been there longer than that.
Oh, man, you know what? Let me get back to his right case. Sorry, I got too many windows open on my screen. Let me start again. This is Christopher Woods, jailing screen going on, and he has been in custody for 14 days.
Yes, Your Honor.
And he's on a $2,500 good bond
Yes, Your Honor.
set by me.
Yes, Your Honor.
Okay, why are we not addressing a bond modification if he wants to get out of jail?
Well, Your Honor, if he can get a signature bond, we would like. He's unable to post the bond that he has. That's why he's still sitting in jail.
All right. Pre-trial, Ms. Washington, can we refresh our memory with regards to his GCIC?
There are multi-state interaction. Can you hear me okay? I'm
Loud
sorry.
and clear. Thank you.
Okay, perfect. There is multi-state interaction in New Jersey and in Georgia.
Yeah, but what is the nature of that interaction?
Just give me one moment, Ms.
Okay.
McLeod. There was a felony conviction for a controlled substance on school property from, it appears 94. All of this is old, out of New Jersey. There is one arrest cycle out of Florida from 2016 for fugitive from justice. There are also 10 arrest cycles out of Georgia, including a 2017 aggravated assault out of Clayton County. The GCIC list that was a NOLO plea. There was also an aggravated stalking in 2010 out of Douglas County. In 2010, also out of Douglas County, there was a simple battery, family violence, and willful obstruction, misdemeanor conviction. There was an aggravated assault in 2008 out of Douglas County, a 2008 misdemeanor conviction for fleeing, also out of Douglas County, and nothing further, Your Honor.
All right, Ms. McLeod?
Yes, Your Honor. It seems to me that everything that pretrial has said, they're old cases. I believe they said something on 94 in New York. And the most recent one I've heard in Georgia seems to be 2017. And that was resolved some time ago. So he does not have any significant criminal history, especially recent criminal history, Your Honor. So that is why I'm asking for time served. If the court feels like he needs to do any kind of courses, whether it's anger management or FVIP, we would be open to that as well. But he would like to get out of jail.
And where will he be staying?
He gave me an address.
Is it the Venetian Drive location?
Yes, Your Honor.
No, he can't stay there. That's where the alleged cross defendant lives.
Okay.
So we have a problem.
Well, I guess if he gets out, Your Honor, the court says he cannot stay there, he would have to find somewhere else to live.
Mr. Scirocco?
One moment, Your Honor. Apologies. Your Honor, we have filed down the added accusation for battery family violence. You've heard his history here. We are looking into a felony transfer. We would maintain that we would ask, this is the first time this has been, I don't think this has been reset before. We would just ask for a one-time continuance so that we can evaluate and determine that this is not, in fact, a recidivist offense that would then belong in Superior Court.
Your Honor, they have had the past 14 days to do so.
I don't, Ms. Champion, do you see it filed in the case right now? Because I know you have it, but it's just not showing up on Odyssey.
Yes, Your Honor, I see that it's been filed out at this time.
Okay, and what are the added charges? Is it, are
The
we
added charge
basing-
was, one of them was the simple battery family violence was amended. I was just looking at the language of that, and that was just, it appears to be a generation error in our system, so I fixed that with the appropriate language. But the added accusation for the second count would be for battery family violence, which is what we would be looking into a felony transfer for. So that's why we're asking for the 1-week reset.
Okay, so the new charge against Mr. Woods is now battery family violence, not simple battery family violence, correct?
Well, it's both, Judge.
Well, you've added a charge to his case.
Yes, it is.
Okay.
The original one I amended, it's still simple battery family violence, but there's an added battery family violence charge.
Understood. Okay. So, Ms. McLeod, presently your client has a new charge of battery family violence. And then,
Yes, Your Honor, we're just learning about that now.
well, welcome to my world. And then he's got the original charge, simple battery family violence.
Yes, Your Honor.
On the battery family violence, his bond is going to be set at 15,000. And I'm going to amend the simple battery family violence to 5,000. It's going to be a total of 20,000. It's going to be a signature bond through pretrial services level 3. He is to have,
Yes, Your Honor.
and you would need to submit the proposed order.
Yes,
He
Your
is
Honor.
to have no further contact with, oh gosh, I knew I had the,
Mary Batson, Your Honor.
He's
Mary
had no
Batson.
further contact with Mary Batson, which means that he has to stay 200 yards away from her. He cannot speak to her, mail, email, phone, third-party communication, none whatsoever. He's to stay away from the 1439 Venetian Drive location in Atlanta, Georgia. He's allowed a one-time visit to that location with a police officer. That visit cannot exceed 1 hour, and he can use that time to retrieve his belongings. Within 30 days, he must update the court with his current mailing address, and it cannot be anywhere near 1439 Venetian Drive in Atlanta, Georgia. Also, within 30 days, he will enroll in a domestic violence intervention program, and this is a series of 24 classes. He will enroll in those classes, and he will complete them without missing and skipping any class. Those charges will have to be paid by him. No illegal drugs, no alcohol, and he's not allowed to own or possess any firearms. If he violates any of these conditions of the bond, he will be rearrested, and his bond will be 20,000 surety at that time.
Okay. So it's 5,000 on the simple battery and 15 on the
Battery
battery.
family violence, correct. And he reports to pretrial once a week. He's on a level 3 report.
Yes, Your Honor. Thank you.
All right. And both these case and this case, 25 CR 5567Y is going to be further notice for trial.
Thank you, Your Honor.
All right. Mr. Spisman, I think you are here on a case where something has happened, and we're going to tell you what happened now.
I think I know, but I'll wait in here.
Who is your client again?
It was Robert Thomas, Your Honor, position 36-ish.
I believe Your Honor reset that 1 week with him being in the other court.
Yeah, Judge, he's in Superior Court, and we have bond reinstated on both of these, so we're hopeful that today he's going to be released.
All right. Then in that event, if he's released, then he'll be further notice for trial. Okay?
Thank you, Judge. Nice to see you. Take care.
You too. Thank you. This was for positions 36 and 37. All right. All right. And then, Francois, who do we have?
Judge, I do have position number 39, Ms. Tisa Tucker, but before we proceed, I do have a quick announcement for position 30. Ramírez Sanchez, I just found out that she needs a Spanish interpreter.
Do you know who's her attorney?
I am, Your Honor.
Oh, Ms. Tucker? Okay.
Yes.
Yes, it was sent out with the announcement that an interpreter was needed, and I also emailed Ms. Champion to see if one would be available today.
All right, let's see if one will appear. Is Miss Ramírez Sanchez available at ACDC?
She's here, Judge.
Okay. All right, let's cross fingers and toes. We have an interpreter. Thank you. Who do you have next to you, Miss Francois?
Number 39, Tisa
39.
Tucker.
Okay. Tasia Tucker is accused of theft by shoplifting and criminal trespass causing damage to property. Case number 25 CR 5565E. And this is from September 12th, 2025. Ms. Tucker, you've been advised of your rights, and your attorney is going to be Ms. Tucker.
Yes, ma'am.
And may I place you under oath for the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Speak up.
Yes, ma'am.
Thank you.
Yes, ma'am.
Mr. Scirocco?
Yes, Your Honor. For count 1, the theft by shoplifting, the state's recommendation is 12 months, serve 28 days, credit for time served 14 days, balance probated, anti-theft course, stay away from the CVS located at 2429 MLK Junior Drive, Southwest Atlanta, and 40 hours community service. Count 2, the criminal trespass damage to property, that would be Noel Prost. We would ask that defense stipulate the factual basis, venue, and identification for purposes of the plea.
We do so stipulate for the purpose of the plea. And Your Honor, I would like to request that she be allowed to go on non-reporting once completing the terms.
Any objection?
There was a First Offender Act sealed felony theft by shoplifting case from this year. So state would object to that.
Is she still on probation?
Um, I can check.
All right. While we're reserve ruling on that issue, Miss Tucker, Miss PD Tucker, while I address defendant Tucker. Miss Tasia Tucker, have you consumed any medicine or alcohol? Can't hear you.
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And if you decide to enter this plea of guilty to theft by shoplifting, misdemeanor, are you doing so freely, willingly, and knowingly?
Yes, ma'am.
And if you decide to do so, you would have to give up your right to a trial. You will not go back to a courtroom to face a judge or a jury, and you won't be able to confront your accuser. You also won't be able to challenge the evidence brought against you and present your own defenses and arguments. The state won't have to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights? Yes or no?
Yes, ma'am.
Okay.
Oh, excuse me. I'm so sorry, Your Honor. The state's offer would not be the same. I believe I misread that prior theft by shoplifting. It looks like it says revoked and sealed. I'm not sure if it was reinstated. This is out of Cobb County. So I don't have an answer for you with respect to whether she would still be on that probation there.
All right. She's also got a DeKalb County hold.
Yes.
And is that for shoplifting too?
It doesn't show me, it just says Warren County hold. I don't have information on that.
And I do not either, Your Honor. Usually I would have some information, but there's nothing showing for me.
All right. Miss Tucker, Attorney Tucker, I'm going to deny the request for non-reporting. I'm concerned about whether she has another open misdemeanor case, and I don't know whether it involves shoplifting, and then she's got this prior shoplifting matter in Cobb County. So I think she needs to be on probation in order to give us some assurance that maybe she won't reoffend.
Yes, Your Honor.
Ms. Tucker, I've denied your request for non-reporting probation. If you decide to plead guilty, you would have to report to probation every month once you are released from all pending holds. Is this something you'd like to proceed? I can't hear you.
Ma'am.
Yes?
ma'am.
Okay. Okay, so then my final question would be, how do you plead to one count of theft by shoplifting?
Yes. Yes.
I accept your guilty plea. Your sentence will be 12 months to serve 28 days, credit for time served 14 days. Once you are released from DeKalb County and any other holds, you will report to Fulton County Probation within 48 hours of that release. While on probation, you will complete an anti-theft class within 90 days of being on probation. You will stay away from the CVS store at 2429 Martin Luther King Drive, Junior Drive in Southwest Atlanta, and you will do 40 hours of voluntary community service at a minimum rate of 5 hours per month. You have to do the community service at any nonprofit agency that's not a church and not a school. The criminal trespass causing damage to property will be dismissed. You will continue to report to probation until the remainder of the 12 months is completed. Thank you.
Next is number 2, Mr. Atkins.
Kaylin Akins is accused of theft by shoplifting from July 16th, 2025 in case 25 CR 5534E. Mr. Akins, you've been advised of your rights and your attorney is going to be Mr. Haddad. Mr. Haddad, this is going to be a bond hearing. Just give me about 10 seconds to get to his case. All right, Mr. Akins was booked into the Fulton County Jail and given a bond of $100 cash only. And to stay away from the Target store in question. Yes, sir.
Your Honor, on behalf of Mr. Akins, I am requesting a signature bond, perhaps through pretrial. And the reason, Judge, is Mr. Akins has a failure to appear, a felony failure to appear 25 SC 001189. He has been accepted into drug court, Judge, and the drug court, the attorney in our office that handles drug court had reached out to me yesterday requesting to see if we can get him essentially a signature bond so he can start the drug court program. As the court is aware, the first, I believe, 18 to 20 months, Mr. Akins will have to report on a daily basis as part of his felony charge, Judge, which basically will require him, and that of course includes counseling and everything else that goes to the drug court. I'm not familiar with the day-to-day program, but it's very intensive. The state's recommendation, I'm not disputing the offer or whatnot, but under the circumstances, and incidentally, drug court, I was also informed that they're willing to take this shoplifting incorporate into their program. So I'm simply requesting the signature bond so we can get out and start with drug court on that case, on the felony case, Judge. That's the bottom line, Judge.
And has Mr. Rhodes been provided documentation that it is confirmed he's been admitted into the drug court program in Superior Court?
Judge, I have emailed Mr. Rhodes. I don't have like an order from the courts, but Jan Hankins with our office is the one that told me that they've accepted Mr. Akins on the felony case into drug court, and they're going to try and get the shoplifting in as well. But in the meantime, and another added condition of bond is a special condition on his release, should the court allow it, is for him to, a special condition for him to enroll in drug court for that particular case. So this way, he's on notice that if he does not enroll or doesn't do what he's supposed to do in the felony drug court, then his probation on this misdemeanor case will be revoked, Judge.
So are you telling me that if he flunks out of drug court, I have to take him back? I don't want him back. I don't want him to come back to me.
No, I think.
No offense, but I don't want him to come back to me.
I'm just saying, Judge, what I mean by that, Judge, is for my purposes,
I understand, Mr. Haddad. I'm sorry, I didn't mean to give you a hard time, but sometimes I have to have a glimmer of humor in this thing. All right, Mr. Rhodes, are you relatively satisfied that he's entering a drug court program?
Yeah, I am. Haddad, I've known him for years, and although there was no official documentation, I know if he said it is in fact true. I do have cause for pause. I don't know if a guilty plea to this charge would prohibit drug court, but I think that the offer was reasonable. He does have 17 cycles, Your Honor. Cycles 16 and 17 were both failure to appears. He has an open failure to appear under 25 FTA 001747 and also an open theft by shoplifting under 23 SC 185671. He is currently on probation, 3 years probation that he just took for felony obstruction under 25 SC 001189. So like Your Honor, I would love to wrap this case up and let him go on about his business, but I will leave it to the court as it relates to what's best. But I do think that the bond in the case right now is reasonable in light of everything that he has going on.
Understood. Mr. Haddad? with the assumption that this misdemeanor offense is going to be consolidated with the drug court program, and if he satisfactorily completes all the conditions, they will also take care of the misdemeanor offense. I mean, I don't have a problem. I'm going to set the bond at $1,000. It's going to be a signature bond through the jail, contingent upon entry into the Fulton County Superior Court Drug Court Program and active participation in the program. I'll do the bond order for this one.
Great. Thank you, Judge.
If he fails the drug court program or is disqualified, he was previously held off from the program, then this signature bond through the jail will be sua sponte revoked and converted to a $1,000 cash bond only, which means that if he fails the drug court program, the signature bond will be revoked immediately. It won't need another court order, and we will have him rearrested with a $1,000 cash bond.
Thank you, Judge.
So we're rolling the dice on him. And like I said, with all due respect, Mr. Akins, I really don't want to see you again. Good luck. And by the way, stay away from all Target stores. Every single one. You see a bullseye on that store, you do not enter it.
Thank you, Judge.
Thank you. All right. Is that for me?
You want it?
It's
got
okay. Francois, who do we have, please?
Next, Judge, I have positions 11 through 12. Ms. Fountain.
Okay. Robin Fountain?
Yes, ma'am.
All right. Miss Fountain, this is going to be a bond hearing. Is that correct, Miss Tucker?
Yes, Your Honor.
All right. So she's got oh dear, 25 CR 001560E, accused of 2 counts of abandonment of a dependent child and disorderly conduct and criminal trespass. And her second case is a bench warrant 25 FTA 001722 from July 18th, 2025. Ms. Fountain, you've been advised of your rights, and your attorney is going to be Ms. Tucker. Give me a moment. Okay. Yes, Ms. Tucker, what's the recommend? She's been in custody now for how long?
124 days total.
Okay.
On this case.
Mm-hmm.
So we are requesting a signature bond from the court. She is 39 years of age. She's lived in the Atlanta area for 21 years now. She was able to provide with an address for her. Prior to being arrested, she was working in the community. So due to the amount of time she served on this, we are requesting a signature bond or that the current cash bond be reduced.
So she was previously arrested on March 24th of 2025, and she was in custody for 94 days. And she made the bond under the 10% program, and she was released on June 25th, 2025. Correct?
And
all right. So then she didn't appear in court before Judge Morrison, and she was rebooked into jail on August 25th. So she's really only been in custody for 32 days based on the bench warrant. She hasn't been.
Yes, I was saying in totality on this case, she served.
Okay. I just want to be sure. Yeah, I understand. I was just trying to figure out how in the world did she get a bench warrant if she's been in custody for over 100 days?
Yes, ma'am. And on the bench warrant, I do see a return to sender, so I do believe it was an issue of an incorrect address. I do see that in Odyssey.
Okay, and what's her address today?
The address she provided me yesterday was 940 Fisher Road, Southwest, apartment A3, Atlanta, Georgia 30315. on the. And
Is that a unit number or an apartment number, or is it a house?
an apartment number?
A3,
Sorry?
A3, A as in apple, and the number 3 is the apartment number.
Okay, so this will be her new address, 940 Fisher Road, apartment or unit A as in apple 3, Atlanta, Georgia 30315, correct?
Yes, ma'am.
Okay. Mr. Rhodes, do you have any concerns about giving a signature bond on the bench warrant now that we have a new address?
Your Honor, I will point out, if I'm not mistaken, I think it's 1940 Fisher Road, not 940 Fisher Road. I believe that it's 1940 Fisher Road.
Well, let's hear it straight from the defendant. What is your current address?
19. Oh, I'm sorry. 19. Now y'all got me all messed up. 9401 Fisher Road. No, I'm sorry. 19. I'm sorry. I'm sorry. Yes, what he just said. Yes, ma'am. Yes, sir, and ma'am.
Okay. I believe she gave me 940 yesterday. It's 1940.
I'm sorry.
Mr. Rhodes, what's the address?
1940 Fisher Road, apartment number A3, Atlanta, Georgia 30315. And Your Honor, as it relates to that particular address, there was a change of address done on March 26, 2025, where defense and Ms. Fountain provided that address to the clerk of courts. And the clerk of courts did mail out a notice for a July 18, 2025 jury trial to that address. My records show that it was mailed to that exact address and there was no return of service. And so she failed to appear on Judge Morrison's July 18, 2025 jury trial calendar. As such, she has a $2,000 cash bond for failure to appear because I believe that this may have been her second failure to appear, Your Honor.
What was the first one? Was it in this case?
I'll have to go back and look. I was of the opinion that she provided the address due to a subsequent prior failure to appear, but let me verify that.
I do see a return to sender in Odyssey. I'm not sure why it's not appearing on the other end, but I have it pulled up.
Okay, so right now she's got a bench warrant on the FTA case because the other one is on the 10% program. I'm going to set aside the bench warrant.
Okay, and Your Honor,
I'm going to reinstate the 10% program that was under the case 25 CR 001560E. She can continue with the 10% program. The 10% program requires her to report to pretrial services. We're going to amend that to a level 3. So Ms. Fountain, you will report to pretrial once a week. Once a week, not once a month, once a week. And every time you go visit your pretrial officer, you're going to ask them when's your next court date, and you're going to confirm with pretrial officer what your current address is at all times. And if you're having a problem with the United States Postal Service, you need to go fix that. Because we are not responsible for that, you are. And if you miss another court date, please remember to bring $2,000 with you because that will be your bond the next time.
Your Honor, I did have to note that it was reset last week for a new program called New Beginning, or does that?
No, I
No?
don't have that.
Okay.
But I do have that she is required to stay away from 1100 Rebel Forest Drive. And have no contact with Freeman Durham. Okay?
And Your Honor, is that 10% off
Tucker?
$1,000?
Yeah, so all I'm doing is setting aside the bench warrant. So it's going to be dismissed. Reinstating her original bond. Ms. Tucker, are we following me so far? I don't want to outpace myself.
Yes, Your Honor, I'm following.
Okay. The current address has to be updated to 1940 apartment A3 at Fisher Road, Atlanta, Georgia 30315. The bond is amended on the 10% program through pretrial, where she reports to pretrial level 3 once a week. And she will check on any upcoming court dates and confirm her mailing address every week.
Yes, ma'am.
All right, and perhaps you might want to reach out to Judge Morrison's division to advise them of such so they can remove the bond forfeiture hearing coming up.
Yes, ma'am.
All right. Yes, Ms. Fountain?
So what does that mean? Am I going home or what does that mean? I don't know.
It means that your original bond that you were released on before, after you served 94 days, remember you got the bond through the Lucretia Doyle program?
Correct.
You're back on that bond, but you report to pretrial services once a week.
So you letting me out or I don't understand what you're saying.
You're being released, but this case is still open and active against you. But the part I want you to understand is that you report once a week, not once a month.
I understand that. That's fine. I agree.
All right.
I just had one quick question.
Yeah.
Is that just one quick question? When I start working again, is that any way going to interfere with me and my job, or I don't know? Like
You can go to work as long as you report to pretrial once a month and you report to court when for your next court date.
Once a week. Once a week for however long.
For however long. Yeah.
All right. Yes, ma'am.
Thank you.
Thank you.
Position number 14.
Joshua Gayer is accused of criminal trespass, theft by shoplifting, and possession and use of a drug-related object from September 12th of this year, case 25 CR 5570D. Mr. Gayer, please raise your right hand for the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Champion, any updates on Spanish interpreter?
No, excuse me, Judge, not as of yet. I'm trying.
Okay, thank you. All right, Mr. Rhodes, what's the recommendation for Mr. Gayer?
Yes, Your Honor, as it relates to count 1, criminal trespass, that's 12 months to serve 60 days.
Mr. Rhodes.
Is this the one that we changed, that you sent me a counter offer for?
Yes.
Let me apologize, 12 months to serve 30 days. Is that correct?
That is
correct. Balance probated.
Okay.
Stay away from the CVS at 2429 MLK Drive, Northwest Atlanta, Georgia, that he undergoes alcohol drug evaluation and treatment, and we agreed on 40 hours of community service at a 501c3 not-for-profit entity. On count 2, the theft by shoplifting is 12 months probation, credit for time served, to run concurrent with count 1. And on count 3, we're asking 12 months probation, credit for time served, concurrent with counts 1 and 2. Thank you, Your Honor.
Mr. Haddad, do you so stipulate?
We stipulate, Judge, ask the court to follow the state's recommendation, Judge.
All right. Mr. Gayer, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
If you decide to plead guilty to these charges, you would have to give up your right to a trial. You will not be able to confront your accuser, challenge the evidence brought against you, be able to present your own defenses and arguments through counsel, and the state won't have to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to criminal trespass, theft by shoplifting, and possession and use of a drug-related object.
Guilty, Your Honor.
Your sentence, oh dear, it's just, no, nothing wrong. I'm just trying to get some information here. Okay. So he's been in custody for 14 days. Any objection to just amending it to 28, credit for 14?
No, Judge, that was my fault, with the math, so I would ask the court for the 28 days, Judge.
And Mr. Rhodes is shaking, so he's good with that?
Yes, Your Honor.
Okay. So on the criminal trespass, the sentence is going to be 12 months to serve 28 days, credit for time served 14 days, balance probated. He will report to probation on Monday before 3 p.m. And at all times, he will stay away from the CVS store at 2429 Martin Luther King Jr. Drive in Northwest Atlanta. Within 10 days of being on probation, he will report to a healthcare provider and undergo an alcohol and drug evaluation and submit to all treatment that's required. He's not to consume any alcoholic beverages, and he's not to consume any illegal drugs, including marijuana. He will also complete 40 hours of community service with any nonprofit agency that's not a church and not a school. And he will start his community service at a minimum rate of 5 hours per month. For count 2, it will be 12 months concurrent with count 1. And for count 3, it will be 12 months concurrent with count 1. That concludes the sentence. Thank you.
Thank you, Judge.
Next, Judge, I have position number 5, Imani Brown.
Okay. No luck yet on Miss Ramirez, Francois, so we're still holding.
Okay, thank you.
Imani Brown's accused of criminal trespass causing damage to property from September 10th of this year, case number 25 CR 5542E. Ms. Brown, you've been advised of your rights. Your attorney is Ms. Tucker. May I place you under oath?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Rhodes, what's the recommendation?
Yes, Your Honor. On the sole count of criminal trespass and damage to property, the state's recommendation is 12 months probation, credit for time served, to stay away from the incident location, which is, I believe Ms. Brown at one point lived there, but she was evicted. And that's 369 McDaniel Street, Southwest Atlanta, Georgia. The incident location, they were gracious enough after speaking with them to waive the damage to the locks. So we won't be seeking restitution, but we would ask for a social work visit to help with housing. Thank you, Your Honor.
Okay. Ms. Tucker,
Yes.
do you so stipulate?
Yes, Your Honor, we do so stipulate. And I would like to make a request to the court. The offer is essentially a time served offer. There's no requirements that will require supervision on probation. So we would ask for the balance to be suspended on this.
Okay, give me a moment, please. I'll place her on non-reporting for 6 months.
Yes, Your Honor.
This is her, she was convicted, she was released on trespass back in May of 2024, rearrested on August 6, 2024, released on August 16th, 2024. She was rearrested on September 11th, and she presently has a hold. And the hold is from Gwinnett County, okay?
Yes, Your Honor.
And she's been in custody for 15 days. Ms. Brown, you will be considered to be on probation with Fulton County for 6 months. It is non-reporting. You don't have to report. But if you get arrested again during the next 6 months, We will be glad to welcome you back and serve out the rest of the 6 months in jail. Would you still like to proceed with the plea? Yes or no?
Yes, Your Honor.
Right. Have you consumed any medicine or alcohol? And have you understood what's going on in your case? You need to speak up.
Yes, Your Honor.
And are you satisfied with your attorney?
Yes, she was great. Thank you.
Okay, very good. If you decide to plead guilty to criminal trespass causing damage to property, you would have to give up your right to a trial. You will not be able to go back to court, face a judge or a jury, as well as your accuser. You will not be able to challenge the evidence brought against you, present your own arguments and defenses, and the state won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of criminal trespass causing damage to property?
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served 15 days. Balance probated, your probation will be non-reporting at all times. And you are to stay away from 369 McDaniel Street in Southwest Atlanta, Georgia. And before you are released from jail, you will need to be interviewed by a social worker for housing purposes. And of course, you'll need to be picked up by Gwinnett County. And let me amend that sentence. It will be 6 months probation, credit for times to serve 30 days, credit for time served 15 days. So Miss Grace, I'm so sorry. I goofed on that one. Did you get the correction?
Yes, Your Honor.
Oh, you did? Okay, great. Thank you. All right, thank you.
Thank you.
Thank you. Number 21, Kendrick.
Keon Kendrick is accused of criminal trespass from September 11th of this year under case number 25 CR 5577G. Mr. Kendrick, you've been advised of your rights and your attorney is Mr. Haddad. This is going to be a plea. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Rhodes, what's the recommendation?
Yes, Your Honor, it's 12 months to serve 45 days, the balance suspended. We ask that he receive credit for the time that he has served. We're asking that he stay away from 4485 Washington Road in East Point, Georgia, and that he know that the suspension means that if he violates that condition of staying away from 4485 Washington Road, that this court can in fact revoke the balance of the suspended sentence. That is the state's recommendation.
All right. Mr. Haddad, is that what your client has agreed to?
Yes, Judge, we stipulate, and based on my calculations, he has 7.5 more days, so 8 days to go, Judge, before he's released.
And he understands that even though he's not placed on probation, that if he gets arrested again, and if the state finds out, then, well, they are going to reinstate the sentence for the remainder of the 12 months.
I explained that to him, Judge, yesterday.
All right. Mr. Kendrick, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
If you decide to plead guilty to this charge, you would have to give up your right to a trial. You will not go back to a courtroom to face a judge or a jury, and you won't be able to confront your accuser. Furthermore, you won't be able to present your defenses and arguments, and the state won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
And you understand that although you won't be on probation, if you get arrested again for anything else, the Solicitor General's office, who is the prosecutor, will move to have your sentence reinstated and to serve out the rest of the year in prison.
Yes, ma'am.
For this case.
Yes, ma'am.
Okay. Given all this information, how do you plead to criminal trespass?
Guilty.
Your sentence is going to be 12 months to serve 45 days. Credit for time served 14 days. I understand you have 8 more days to serve at the Fulton County Jail. Once you have completed these 8 additional days, you will be released. The remainder of the sentence is suspended, contingent upon you not being arrested again. You are to stay away from 4485 Washington Road in East Point at all times. Understood?
And Your Honor,
Thank you.
that's Chevron gas station.
Oh, is it a Chevron gas station? Okay. Well, now he knows.
Thank you, Judge.
Thank you. Francois, what are we doing?
Yes, Judge. For position number 30, Ms. Ramirez Sanchez, are we going to be waiting? Did you want us to wait a little longer, or is this going to be a reset?
Let me check. Courtroom 2, do we have any more cases to address?
Yes.
We do, Judge.
All right, please hold, Francois, until I'm concluded with courtroom 2.
Number
Thank
32.
you.
Number 32, Sims.
Okay. Marcus Sims is accused of 2 counts of battery family violence and 2 counts of simple battery family violence from December 10th, 2024, case 25 CR 5262B. Mr. Sims has been advised of his rights. His attorney is Mr. Haddad. And may I place you under oath, sir?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am, I do.
Thank you. And Mr. Scirocco, what's the recommendation for Mr. Sims? 2, 3, and 4 will merge, okay?
Okay, yes, Your Honor, for 1 second, I have it right here. For count 1, the state's recommendation on the battery family violence would be 12 months served, 220 days credit for time served, balance probated, firm to complete FFIB, ADET, no further contact with Stacy Laidler, no firearms, and 40 hours community service. And as the court stated, counts 2 through 4 would merge with count 1. We did receive subsequent documentation from defense showing additional credit that he would receive time for, and I will let PD Haddad go into that. We would ask defense stipulate the factual basis, venue, and ID for purposes of the plea. And if we could sound for Miss Laidler as well.
Okay, so for this incident from December 10th, 2024, Mr. Sims was booked into the Fulton County Jail. I guess the warrant was executed and he was booked in on September 3rd, 2025. Which gives him credit for 23 days at the Fulton County Jail. Okay, so Mr. Haddad, am I giving him more time as credit?
We are requesting, Judge. My client was arrested in Clayton County March the 8th, and a hold was placed from Fulton County for this case on March 8th, Judge. So he has been in continuous custody since March 8th until he was recently transported, I think the first week in September, back to Fulton County. So we don't, there's no issue as far as the requirements with FFIP and community service and to stay away. What we're requesting is that he gets credit from March 8th, essentially time served because he's been in for that long, Judge.
Was he arrested on the Fulton County warrants in Clayton County, or was he arrested on other unrelated charges?
He had unrelated charge in Clayton County, Judge.
And what were those charges?
I'm sorry, Judge.
It's news to me.
It's a theft by taking, Judge. I think if I can look up the paperwork, but the incarceration.
You're asking me to give him credit for time served for a charge that was allegedly committed in a different jurisdiction.
And Your Honor, if I may, so he gets arrested on the theft by taking Clayton County March 8th.
Okay.
All displaced from Fulton County for this case. So he, in essence, he is serving, time on the theft by taking in Clayton County, but he also has that hold from Fulton. It took
But was he in Clayton County because of the bond in Clayton County, or what, did he receive a signature bond and we just took our own time picking him up? Which
No,
one is it?
the court did not, I mean, sorry, not the court, the county, Fulton County, he did not get a signature bond in Clayton County. He had a bond, but he couldn't make bond in Clayton County. So he remained in Clayton County. He remained in Clayton County for the theft by taking, but also he had that hold from Fulton. Once he was able to resolve the Clayton County charge, then it was only then they was transported to Fulton.
Okay, and can you go ahead?
Judge, I mean, I understand, I know where the court's coming from. I'm simply requesting under the circumstances, he has been in continuous custody since March 8th. The plea offer recommends another, I mean, in other words, 220 days. So that's more time. If the court were not to give him credit, then, you know, we'll just enter a plea of not guilty. He's trying to resolve the case by admitting guilt and moving on. And starting the classes, Judge. That's my request.
That's not how this works. That's not how this works. I'm glad that he wants to plead guilty and that he wants to move on. That's fine. I'll be glad to send him to prison for 1 year because that's the maximum sentence he receives. And just because he decides he wants to move on because he's pleading guilty, that doesn't make it all okay and peachy. All right? I'm going to give him due credit for any charges that he's allegedly committed. But I'm not going to give him credit because he had to sit in Clayton County for an offense that he allegedly committed in Clayton County.
Understood, Judge. We'll just plead him not guilty then.
Now, before you jump over that fence, I am open to amending it to a sentence of to serve 60 days, credit for time served 20 days.
That's fine, Judge. And I jumped the gun on that one. I appreciate the court's patience with me. I explained to my client based on my terrible math that he'll have another 10 more days to do before he's released on probation, Judge. But based on that, Judge, he's willing to plead guilty this morning, Judge.
Your Honor, if that is what the court intends to do, the state would, we would want to put what is necessary here on the record with respect to his history.
Please do. Definitely, definitely. And let me see. So, according to my bad math, he would have 7 more days to serve at the Fulton County Jail, and then he'll be placed on probation. Yes, sir. Mr. Scirocco?
So, Your Honor, this incident took place. This was December 10th through the 11th of 2024 at 1033 Hollywood Road, Northwest Atlanta. Law enforcement responded to a dispute call and made contact upon arrival with Miss Stacy Laidler. She explained the defendant, who had been living with her and in a relationship with her, had assaulted her. He had become intoxicated, became aggressive in the house. He punched her in the face, leaving a mark on her left cheek, struck her in the chest, and also burned her left thigh with a blunt cigar. She sustained visible injuries. There was a mark on her cheek, a burn mark on her left thigh, and she positively identified the defendant as the one who attacked her. With respect to his history, the state has a number of convictions here. We're looking at, briefly in terms of older history, simple battery family violence conviction from 2004, battery and false imprisonment from 2006, aggravated assault, aggravated battery from 2009, and DUI drugs conviction there as well as a hit and run. Felony terroristic threats and acts, 3 counts, simple battery, 3 counts, false imprisonment, that's from 2015, that's that conviction, excuse me. There's also, and most recently, an aggravated assault and criminal trespass conviction from 2023. And I will note, while that is explicitly charged as an ag assault, I don't see a family violence designation there. And we looked into that. He was sentenced to 7 years probation, 3 years confinement, and was ordered to complete a certified family violence intervention program along with ADET. and was ordered to have no further contact with the victims, though those are different victims than Miss Laidler here. So there is a long history of violence here. And we are concerned for reoffense, and this is absolutely a very serious case, especially the burning of her leg with a cigar. It's just downright abusive, obviously. So that is the rationale behind the state's recommendation. The count 1, 12 months served 220 days with credit for time served, balance probated, FFIB, ADET, no further contact with Ms. Laidler, no firearms, and 40 hours community service. We think that is the appropriate recommendation here and the appropriate sentence. So we would object to a reduction in the time to serve here if the court would be so inclined.
No, I think the history is very troubling, like you said, and the original offer was to serve 220 days credit for time served, which was going to be applied from the Clayton County. So clearly the state was willing for him to go back, but he would have had a very shortened time on probation under the state's curated plea offer. In the meantime, the states also agreed to merge 3 of the other violent charges into count 1. That's the state's offer. And considering the alleged burning on the thigh, that should have been charged as an aggravated assault, but
we attempted to send it up, Your Honor. It was rejected.
Okay, so it was rejected, so he's back with us.
Mm-hmm.
And I don't have a problem with sentencing him to 12 months probation, credit for time served, what was it, to serve 60 days, credit for time served 23 days. He has 7 more days to serve in the Fulton County Jail. And this would be for count 1. And then for count 2, battery family violence, if he will have to plead guilty to that as well. And that will be concurrent with count 2, that would be concurrent with count 1. And the 2 counts of simple battery family violence, I will merge that into count 1. So it'll be 2 counts of battery family violence, and it would be conditions that he reports to probation twice a month for the rest of his probation time, and that he is required to complete the FFIB, the ADET, have no contact, no firearms, and stay away in 40 hours community service. I don't have a problem with that.
Judge, my client is ready to proceed with the plea.
2 counts of battery family violence, and I merge the 2 counts of simple battery, correct?
Yes, Judge.
And Mr. Sims, if I see you in court again, I'm not going to be this nice anymore. Do you understand?
Yes, ma'am, I understand.
Okay, you've just heard your history. You're not a very impressive young man, so I don't like impressive young men, and you certainly leave that impression. Understood?
Yes, ma'am.
All right. And do you stipulate to the factual basis, venue, and ID to the 2 counts of battery family violence, Mr. Haddad?
We stipulate, Judge.
All right. This, as we can establish, is a non-negotiated plea. Mr. Sims, have you consumed any medicine or alcohol recently?
No, ma'am.
Have you understood what's going on in your case?
Yes, ma'am, I do.
And are you satisfied with your attorney?
Yes, I am, ma'am.
If you decide to enter this plea to 2 counts of battery family violence, this will show up on your criminal history record, which means that any subsequent arrest for a same or similar offense will be a felony charge. Do you understand that?
Yes, ma'am, I do.
If you decide to enter this plea, you would have to give up your right to a trial. You will not be able to go back to court to face a judge or a jury. You will not be able to confront your accuser, challenge the evidence brought against you, and the prosecutor won't have to carry his burden of proof with regards to the 4 charges brought against you. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to count 1 and count 2 for each charge of battery family violence?
Guilty, ma'am.
Counts 3 and 4 will merge into count 1. For count 1, your sentence is going to be 12 months to serve 60 days, credit for time served 23 days. After you've completed the 7 days, you will report to Fulton County Probation within 48 hours of being released. While you are on probation, you will report to probation twice a month. Do you understand?
Yes, ma'am.
You will report to probation for the remainder of the 12 months, less the 60 days. Also, within 30 days, you will enroll in a domestic violence intervention program, and you will show proof of that enrollment. And this must be done within 30 days of being on probation. You must attend and complete all 24 classes without missing or skipping any class, and you will pay for those classes out of your own pocket. Within 10 days, you will undergo an alcohol and drug evaluation and submit yourself to any treatment. While you are on active probation, you will not consume any alcoholic beverages, and you will not consume any illegal drugs, including marijuana. You will be subject to mandatory monthly screens by probation for illegal drugs and or alcoholic beverages. At all times, you have to stay 200 yards away from Stacy Laidler. You're not to communicate with her in any way, form, or manner, including in person, mail, email, third party, phone, computers, and even on social media. By law, you're not allowed to own, possess, or have any firearms anywhere near you. You're also to complete 40 hours of voluntary community service with any nonprofit agency, and you will complete a minimum of 10 hours per month with any nonprofit agency, and it cannot be a church and it cannot be a school. For count 2, battery family violence, it will be 12 months probation concurrent with count 1. Again, report to probation twice a month. Counts 3 and 4 will merge into count 1. Any questions, Mr. Haddad?
No, thank you, Judge.
All right. Please make a note. This is mandatory screening every month, once a month.
Yes, ma'am.
All right. Position Miss Ramirez, position 30. We have Miss Ada Lean.
Good morning. Good morning, Your Honor.
It's still morning, Miss Lean. Barely, but it still is.
That's right.
Francois, we are ready with Miss Ramirez. Miss Tucker?
Yeah, Your Honor, I haven't had an opportunity to speak with Ms. Ramirez due to the language barrier, so I believe this is the last defendant in this courtroom, and then we can go on a breakout.
No problem. How would you like to communicate through a breakout session? Do you have a separate device?
Oh, well, yes.
If you can get on a separate device, I can place you into a breakout with AC/DC and Miss Lean. A laptop or a phone, iPad.
You can use my phone.
If there's difficulty, we can wait a little.
Yeah,
That's what I asked.
yeah, if we can wait until we,
Okay.
the mic on the laptop does not work.
All right. All right. I'm so sorry. Ms. Ramirez, Francois, we have to wait until we can put Ms. Ramirez in a breakout with her attorney. All right. And who do you have, Mr. Haddad?
Number 38 Talbert.
Okay. This is Robert Thomas accused, oh, excuse me. This is Anthony Jeremiah Talbert, accused of criminal trespass from July 2nd, 2025, in case 25 CR 5531C. Mr. Talbot, you've been advised of your right to remain silent, and your attorney is Mr. Haddad. This is going to be a negotiated plea. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Mr. Scirocco?
Thank you, Your Honor. The state's recommendation for this case on the criminal trespass is 12 months, serve 30 days, credit for time served, balance probated, stay away from all GSU premises and property, and 20 hours community service. We ask that defense stipulate the factual basis, venue, and ID for purposes of the plea.
John, we stipulate for purpose of the plea, I would just ask the court to consider waiving the first 2 months of probation fees. My client has employment and housing challenges, Judge, and that's where I'm at.
Okay. I will waive the probation fees for the first 2 months, and as long as he reports to probation
I'm understanding I was do 20 hours of community service.
Well, yeah, but you still report to probation.
Just have to report.
But if you don't want to report to probation, then I can just double the time that you've been in jail.
What I'm saying is it 20 hours community service or is it probation? I was never advised to be put on probation.
Mr. Haddad, could you please
Sure.
enlighten him? Is stay away from all GSU and 20 hours of community service, and I'll waive the probation fees for the 2 months and put him on non-reporting.
All right, just 1 second, Judge. Thank you.
Um, Ready, Mr. Haddad?
I am, Judge. Thank you for the moment with my client. I explained to him about how community service works and more importantly, how probation works. And he's ready to proceed based on the negotiated plea. Explained to him that he'll have to report to probation when the court asks him to report, which I presumably will be sometime next week, Monday, perhaps.
Definitely Monday. Okay. Just one thing. Yeah, he's been in custody for 15 days, so that's good. All right, Mr. Tolbert, and you so stipulate, correct, Mr. Haddad? I'm so sorry.
You, Judge.
Okay. Mr. Tolbert, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood now what's going on in your case?
Correct.
Are you satisfied with your attorney?
Sure. Yes, ma'am.
All right. And if you decide to plead guilty, you would have to give up your right to a trial. You will not be able to go back to court, face a judge or a jury and your accuser. You will not be able to challenge the charge brought against you, and the state won't have to prove it beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of criminal trespass at Georgia State University?
Guilty.
Your sentence is going to be 12 months to serve 30 days, credit for time served 15 days. You don't have any other holds, so you should be released within 24 hours. You will report, listen very carefully. You will report to Fulton County Probation at 132 Mitchell Street in downtown Atlanta on Monday before 3 p.m. That is Monday, September 29th. Do you understand?
Sure. Yeah. Could I get the address written down?
Yeah. I'll give it there.
Okay. And you must report before 3 p.m.
Okay.
I will waive your probation fees for the month of September, October, and November. Do you understand?
Yes, ma'am.
No, don't read. I need you to pay attention. You will complete 20 hours of voluntary community service at any nonprofit agency like Goodwill, Salvation Army, the Atlanta Food Bank, any kind of charitable nonprofit agency, and it cannot be a church and it cannot be a school.
Okay.
And you must complete all 20 hours by the end of November 2025.
Okay.
And if you complete everything by the end of November 2025, then your probation will be non-reporting.
Okay.
But if you're not done with your community service, you will continue reporting to probation, and on December 1st, 2025, you will start paying probation fees.
Okay.
At all times, you must stay away from all Georgia State University property.
Okay.
If you get arrested again for anything else, including trespass at GSU, this probation will be revoked and you will serve out the rest of the 12 months in jail.
Okay.
Okay, sounds good to me. This concludes the plea.
Thank you.
Miss Grace, can you place courtroom 2, Miss Tucker and ACDC and Miss Ada Lean in a breakout room, please?
Yes, ma'am.
All right. And then we will resume with the, I think we don't have a bench warrant, do we? To address?
For position 30, Judge?
Oh,
Or do you mean a bench warrant calendar?
no, there's no DV bench warrant calendar.
Right.
So we only have the competency calendar coming up. So while Miss Tucker and ACDC and Miss Lean are in a breakout, I'm just waiting for them to go into a breakout. We're going to give Miss Greenhouse a much needed break. Okay. And we'll be back as soon as Miss Tucker responds. So let's ballpark it at about 12:01, 12:02, and then we'll resume. Thank you. Okay, Ms. Tucker, we are addressing position 330. How is your client going to proceed?
Yes, ma'am. It'll be a negotiated plea.
Ms. Lee?
Yes, vamos a proceder ahora con el caso de la señorita, la posición número 30. La juez le preguntó a la abogada cómo se va a declarar usted y usted dice que usted aceptó la oferta que el convenio precondenatorio que se le ofreció.
This is case 25CR 5551G. State, sorry, go ahead.
Este es el caso 25CR00551G.
State versus Jennifer Ramirez Sanchez, charged with 2 counts of misdemeanor theft by shoplifting.
Contra el estado de Georgia contra la señora Ramírez Sánchez Jennifer, que tiene 2 cargos de delito menor de ratería de tienda.
Incident date is April 6, 2025.
El caso ocurrió, la fecha fue el 6 de abril del 2025.
Ms. Ramirez, you have a right to remain silent. Anything you say in open court about your case, your statements can and will be used against you.
Señorita Ramírez, usted tiene el derecho a permanecer en silencio. Cualquier cosa que usted diga o declare aquí, en este momento, puede ser usado en su contra.
You have a right to an attorney. If you cannot afford one, one will be appointed to represent you, and presently your attorney is Ms. Tucker.
Señorita, usted tiene derecho a tener un abogado que la represente. Usted no puede contratar a su propio abogado, se le nombra un abogado de oficio. En este caso, su abogado de oficio que se le ha nombrado es la señorita Tucker.
May I place you under oath for the purposes of this plea hearing?
La voy a poner bajo juramento. Si puede levantar la mano, señorita Ramírez. You need to swear me in too, because I don't think.
You're correct, Ms. Lean. Let's do the defendant first.
Okay. Levante su mano derecha, señorita Ramírez.
Ms. Ramirez, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Señora Ramírez, usted jura o afirma que el testimonio que está presentando aquí es la verdad según lo que usted sabe.
And I apologize, Ms. Lean, I thought I had done it. Do you solemnly swear and affirm that the testimony you translate so far and moving forward is going to be a true and accurate translation with no changes or embellishments?
I do.
Thank you. Mr. Scirocco, if you would like to present the state's offer, keeping in mind we have a interpreter.
Yes, Your Honor. The state's offer on this case for the 2 counts of theft by shoplifting
La oferta que presenta el fiscal en el caso que tenemos aquí presente de 2 cargos de delito menor de ratería de tiendas
is as follows. For count 1, it's 12 months probation, served 32 days with credit for time served.
Okay, para el cargo número 1 tenemos la propuesta de el primer cargo de ratería de tiendas, son 12 meses de libertad vigilada, 32 días de cárcel y se reconoce el tiempo que ya cumplió, 16 días.
Balance probated while on probation, complete an anti-theft course, 60 hours of community service, and stay away from the Rack Room Shoes at 7671 North Point Parkway in Alpharetta.
Okay, también se le va a imponer que tiene que tomar un curso de antirrobo ratería de tiendas y tiene 60 horas de servicio a favor de la comunidad y se le exige que se mantenga alejada de la tienda de Rack Room Shoes en el 7671 en North Point en Alpharetta.
For count 2, the other theft by shoplifting, the state's recommendation is 12 months probation concurrent with count 1.
Para el cargo número 2 de ratería de tiendas, la Fiscalía está proponiendo otra libertad vigilada que se va a cumplir al mismo tiempo que el cargo número 1.
And to stay away from 1125 Woodstock Road in Roswell, which is the other Rack Room Shoes location.
Y es mantenerse alejada de la otra tienda de Rack Room Shoes que está en el 1125 Woodstocks Road en Roswell, que es la otra tienda de Rack Room Shoes.
And we would ask that defense stipulate the factual basis, venue, and identification for purposes of the plea. That is all for the state.
Y también pedimos que la parte defensora presente la jurisdicción y la identificación para el cargo.
We do so stipulate for the purpose of the plea.
Y ellos estipulan en relación a la declaración de culpabilidad.
All right, before I proceed with the plea, I recollect this case.
Antes de proceder con esto, yo recuerdo de este caso.
And just to confirm, Ms. Ramirez Sanchez has a hold in Cherokee County.
Solo para confirmar, la señorita Ramírez tiene una orden de detención en el condado de Cherokee.
She has a hold in Roswell, Georgia.
También en Roswell, Georgia, tiene otra detención.
And she has an immigration hold from the jurisdiction of Greenville, I want to say South Carolina.
Y creo que tiene también una detención de migración en Greenville, en Carolina del Sur.
But I may be wrong with regards to which Carolina I'm referring to.
Pero puede ser que esté equivocada en relación a cuál de las Carolinas me estoy refiriendo.
That is what the state has as well.
Yes, Your Honor, I did discuss the holds with my client. She is aware.
All right. And so the state and the defense understands that the only way she will start probation is once she is released from all these holds.
Y la fiscalía y la defensa entienden que la única forma de que ella pueda comenzar libertad vigilada es cuando ella libere todas estas detenciones.
Yes, Your Honor.
State
And,
is aware.
all right, and the state also understands that I have no idea when she will come back to Fulton County.
Y la fiscalía entiende que yo no tengo idea cuándo ella regresará al condado de Fulton.
State understands, Your Honor.
Ellos entienden.
If Ms. Ramirez Sanchez is released from these holds, this probation will still be outstanding against her.
Si la señorita Ramírez puede solucionar y liberarse de todas estas detenciones, la libertad vigilada sigue pendiente en su contra.
And if she doesn't return to Fulton County, Georgia to start probation, she can be arrested no matter where she is in this country.
Y si ella no regresa para el condado de Fulton, aquí para enfrentar la libertad vigilada, ya la pueden arrestar en cualquier sitio que se encuentre en el país.
Ms. Ramirez Sanchez, do you understand this position?
Señorita Sánchez, ¿usted entiende esta resolución, este fallo? I don't think she has the microphone on, Your Honor.
It's on, she just needs to speak up louder.
Okay, hable más duro porque no la oímos.
Tengo una pregunta.
¿Entendió lo que dijo la juez?
Sí, sí, señora.
Yes, I understood what the judge said.
Okay. Ms. Ramirez Sanchez, have you consumed any medicine or alcohol recently?
Señorita Sánchez, ¿ha ingerido algún tipo de medicamentos o alcohol recientemente? Hable duro.
No, señora.
No, ma'am.
Have you understood what's going on in your case?
¿Ha entendido lo que está ocurriendo en su caso?
Sí, señora.
Yes, ma'am.
Are you satisfied with your attorney?
¿Está satisfecha con la representación de su abogada?
Sí, señora.
Yes, ma'am.
And do you understand that if you decide to plead guilty to this theft by shoplifting charges, you will not have the chance to have a trial in your case?
Y usted entiende que si usted decide declararse culpable a estos dos cargos de ratería de tienda, usted no va a tener el derecho o renuncia a su derecho a tener un juicio. ¿Entendió esto en su caso?
You will not be able to face your accuser, challenge the case against you, and the prosecutor won't have to prove the charges beyond a reasonable doubt.
Usted no va a poder encarar a los que lo acusan, no puede refutar lo que ellos dicen y la fiscalía no va a tener que probar su culpabilidad más allá de una duda razonable. ¿Entendió esto?
Are you prepared to give up these rights?
¿Está lista para renunciar a estos derechos?
Sí, señora.
Yes, ma'am.
How do you plead to 2 counts of theft by shoplifting?
¿Cómo se declara a los dos cargos que tiene de ratería de tiendas?
Culpable.
Guilty.
Count 2 will be 12 months probation concurrent with count 1.
Cargo número 1 van a ser 12 meses de libertad vigilada al mismo tiempo que el cargo número 2.
And for count 1, it will be 12 months probation to serve 32 days, credit for time served 16 days.
Y entonces por el cargo número 1 van a ser 12 meses de libertad vigilada de cumplir 32 días de cárcel. Se le reconoce el tiempo que ya cumplió 16 días.
Your probation will be on hold until you have resolved all your other matters.
Su libertad vigilada se va a mantener pendiente hasta que usted haya resuelto todos sus otros asuntos.
And you return to Fulton County to start probation.
Y usted regrese al condado de Fulton para comenzar su libertad vigilada.
While you're on probation, you will complete an anti-theft class within 60 days of reporting to probation.
Mientras esté bajo libertad vigilada, cuando regrese tiene que hacer un curso que es antirrobos o antirratería de tiendas y tiene 60 días para poder hacer este curso. Una vez que se reporte con que se presente con libertad vigilada, tiene 60 días a partir de eso.
You will complete 60 hours of community service with any nonprofit agency at a minimum rate of 10 hours per month.
Y va a tener que hacer 60 horas de servicio a favor de la comunidad con una institución que sea sin fines de lucro y va a tener que hacer a un paso de mínimo 10 horas al mes.
The community service cannot be at a church and it cannot be at a school.
No puede hacerlo ni en una iglesia ni en una escuela. El servicio comunitario no puede hacerlo en esos sitios.
You are to stay away from the Rack Room Shoes at 7671 North Point Parkway in Alpharetta, Georgia.
Tiene que mantenerse alejada de la tienda de Rack Room Shoes en Alpharetta, en el 7671 North Point Parkway.
You're to stay away from the Rack Room Shoes at 1125 Woodstock Road in Roswell, Georgia.
También tiene que mantenerse alejada de la tienda de Rack Room Shoes en Roswell, Georgia, en el 1125 Woodstock Road.
The community service and the anti-theft class.
El servicio comunitario y la clase anti-hurto.
The court will only accept those that apply to this probation.
El juez solamente va a aceptar los que apliquen a esta libertad supervisada.
The court will not accept previously completed programs for this probation.
La juez no va a aceptar otras clases que usted haya completado anteriormente a esta libertad supervisada.
Do you have any questions, Ms. Sanchez?
¿Tiene alguna pregunta, señorita Sánchez?
Sí.
Yes. ¿Qué pregunta tiene?
Lo que pasa es que yo no vivo aquí en Georgia, yo no vivo aquí en Atlanta, yo vivo en New York.
¿Vive dónde?
En New York, en Nueva York.
Oh, the problem is that I don't live here in Georgia, in Atlanta. I live in New York.
Well, the problem is these crimes were committed in Fulton County, Georgia, so you would have to come back to Georgia to complete these penalties.
El problema es que estos delitos fueron cometidos aquí en Atlanta, en Georgia. Usted tiene que regresar a Georgia para poder cumplir con todas estas penalidades.
Your Honor, I would like to request on her behalf that once she does the initial check-in with probation in Fulton County, that she be allowed to report over the phone.
No.
La abogada pidió de que le permitiera a la juez que usted una vez que se presentara por primera vez en libertad vigilada, que después lo hiciera por teléfono, pero la juez se negó a aceptar esa solicitud, no lo va a permitir.
Based on the allegations in this case, based on the information I received at first appearance, I believe that Ms. Ramirez Sanchez may be part of a serial shoplifting gang.
Debido a que yo recibí información durante la comparecencia inicial, tengo información de que la señorita Ramírez puede ser parte de una pandilla en serie de ratería de tiendas.
There is serious concerns about her reoffending or being affiliated with individuals who shoplift.
Hay mucha preocupación de que ella puede volver a hacer esto y de que esté asociada con otros individuos que están realizando ratería de tiendas.
Anything else, Ms. Tucker?
¿Algo más, señorita Tucker? No.
Ms. Ramirez Sanchez, do you understand the court's position on why you need to complete probation in Georgia?
Señorita Ramírez Sánchez, ¿usted entiende la posición o la postura de la juez en la cual por qué tú tienes que completar libertad vigilada aquí en Georgia? ¿Entendió la explicación de la juez? Yes.
Aquí en Georgia.
¿Ah?
Yo no tengo a nadie aquí en Georgia, toda mi familia está en Nueva York.
I don't have any family here in Georgia. All my family is in New York.
That's unfortunate.
Es muy desafortunado.
Thank you.
Gracias.
Your Honor, we have
Milton, was it Milton at ACDC? Oh, Francois, we're done. Thank you.
May I be excused, Your Honor?
Yes, Ms. Lean, thank you so much.
You're very welcome.
Who do we have in courtroom 2?
number 35, Thomas.
35, right? Okay, thank you. This is Kirk Thomas accused of theft by shoplifting from September 10th, 2025 in case 25 CR 005545C.
And Your Honor, I neglected to request, instead of in lieu of the $500 fine, I wanted 50 hours community service. I forgot to email the state judge.
All right. I don't know what the state's position is on that, but let us progress and I'll see. I'm going to reserve ruling on that.
Thank you, Judge.
Mr. Thomas, you've been advised of your rights and your attorney is Mr. Haddad. May I place you under oath for the purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. Scirocco, what is the recommendation for Mr. Thomas?
Yes, Your Honor. For the theft by shoplifting, the state's recommendation is 12 months, served 28 days, credit for time served, balance probated, complete an anti-theft course, a $500 fine per the statute. He has a 2016 shoplifting conviction in Georgia. Stay away from the Walmart at 844 Cleveland Avenue in East Point. He also has probation violations as recent as this year.
All right.
We would ask defense stipulate a factual basis, venue, and ID for purposes of the plea. Thank you.
Mr. Haddad, okay, let me see. He received a $75 cash bond. Were the probation violations in Fulton County? I see one from 2018. So
I can check on that, Your Honor. I just wrote down probation violation. Excuse me, it's taking a second. There's a multi-state history here. Probation violation was out of the Georgia. It does say, Clayton County Sheriff's Office.
okay, all right. I'll agree to amend that to 50 hours of community service, but he'll be required to report to probation every month for the remainder of the 12 months.
Acceptable, Judge. Thank you.
Okay. So, Mr. Haddad, do you stipulate to the factual basis, venue, and ID?
We do.
Okay. Mr. Thomas, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your attorney?
Yes.
If you decide to plead guilty to this charge, you would have to give up your right to a trial. You will not go back to court to face your accuser, challenge the evidence brought against you, be able to present your arguments and defenses, and the state won't have to prove the charge beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of theft by shoplifting from September 10th?
Guilty.
Your sentence is 12 months to serve 28 days, credit for time served. I think it was 14 days. Would that be accurate?
It was more, but doable.
Just 1 second, Judge.
You were arrested on September 10th. How was it more?
Just a couple of days.
This is Kirk Thomas.
I'm showing that he was booked on the 12th of this month, Your Honor.
Your Honor, he has credit for 14 days. I think the recommendation is 28 days.
Correct.
So
So I just want to be sure that I'm giving him credit for 14 days, another day more.
yes, Judge, it's accurate.
Okay. So the sentence, as I was saying, is 12 months to serve 28 days, credit for time served 14 days, balance probated. If he has no other holds, he will report to probation on Monday before 3 p.m. While he's on probation, he will enroll and complete an anti-theft class within 90 days of reporting to probation. He will also complete 50 hours of community service, which is the conversion from the $500 fine, and he will he will undertake the community service hours at any nonprofit agency that is not a church and not a school. And he must complete his community service at a minimum rate of 10 hours per month. He's to stay away from the Walmart store at 844 Cleveland Avenue in East Point, Georgia. And if he is arrested again while he's on probation, probation's authorized to issue a warrant to have this revoked and him serve out the rest of the 12 months in jail. He will report to probation every month and be up to date with his probation fees. Thank you.
Thank you, Judge.
To you also.
Thank you, sir.
All right. I have no one else in courtroom 2 and no one else at ACDC, but I have these couple of positions that position 13.
Your Honor, we're going to reset him for next week.
Okay, so position 13 is going to be reset to October, was it the 2nd?
Yes, Judge.
Okay. And then position 16, Ronald Lee Hampton, that was Miss McLeod's case. Miss McLeod, have you had a chance to speak to Mr. Hampton? Did we take a plea in that case?
I think we resolved Hampton. Position 16 is our.
Was that a plea? Yeah, it's 58 days credit for time served, 29 days.
But that's 15.
April, was that a plea?
So yes, Your Honor.
Oh, no, sorry, I got the wrong number. That was a plea. Position 15 was a plea. I'm asking about 16, Nikhil Harvey.
Judge, Mr. Harvey could not be located, so I'm going to have to reset him till next week.
All right, reset to October 2nd, SAP calendar. And then position 19, Lorenzo Henderson.
That's a conflict case, and the notes indicate that it was either being transferred or is going to be transferred to Superior Court.
Mr. Scirocco or Mr. Rhodes, are we transferring position 19 to I see transfer to Superior Court as battery MFB.
Yes, Your Honor. That in that case has already been filed down, and the clerk's office has already converted it from a battery to a battery family violence in the DA's office. I am just waiting for them to say that they would accept, but obviously by matter of law, they're likely going to accept it.
Okay, so I'm going to reset this to September 30th, pending the transfer.
Thank you, Judge.
Okay. The next one was position 22, Laulusa, position 22 and 23.
It's same announcement. He apparently could not be located, so I'm going to have to reset him till next week.
All right, reset to October 2nd for positions 22 and 23. And then position 25, Renard McLeod.
It's going to be a waiver, Judge.
All right, that's going to be further notice for jail jury. All right, are there any other positions that anyone is inquiring about the status? Mr. Haddad, we good?
Yeah, I think we're caught up, Judge.
All right, Miss.
Are we done at Fulton ACDC?
I think so.
Yes.
Francois?
Yes, Judge, we're done here with court. I just had a quick announcement for you. It has nothing to do with court, though. but whenever you're done with,
Okay,
proceeding
I
before
have about 5 cases to do on my competency calendar, and then we'll come back.
Okay.
All right. Anybody else who's not involved in the competency calendar, you're more than welcome to leave. I just want to confirm one thing. Is Mr. Bartel going to be with us today?
No, Judge, it's gonna
Will be
be,
you?
yes.
Okay, no
Not
problem.
the version of Mr. Bartels.
No problem. Miss Grace, can we stop the live stream and the recording? And yes, Miss Greenhouse, I'm going to ask that question too. Mr. Haddad, are any of the 5 cases taking a plea today?
No, Judge. They are not.
Okay, thank you, Miss Greenhouse. You enjoy the rest of the week. Appreciate it.
Thank you. Thanks so much.